ಆಶ್ಚರ್ಯ ಆಗುತ್ತೆ.
ಅದೇ ನಾವು ಬರೀತೀವಲ್ಲ ರಿಜಿಸ್ಟರ್ P&H ಅಂತ ಡಿಸ್ಪೋಸ್ಡ್ ಬಿಫೋರ್ ಅಲ್ಲ ಯಾವ ಡೇಟ್ ಡಿಸ್ಮಿಸ್ಡ್ ಆಸ್ ವಿತ್ಡ್ರಾನ್ ಅಂತ ಮಾಡ್ಕೊಂಡ್ರು. ಅದೇನಾಗಿದೆ ಪ್ರೀವಿಯಸ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗೋಗಿದ್ಯಾ ರಿಜಿಸ್ಟರ್ P&H ಅಂದ್ರೆ ರಿಜಿಸ್ಟರ್ PH ಮುಂದೆ ಇರುತ್ತೆ. ಅವ್ರು ಲಿಸ್ಟ್ ಮಾಡೋವಾಗ ನಮ್ ರೋಸ್ಟರ್ ಅವ್ರು ಏನೋ ಮಾಡ್ಬೇಕಲ್ಲಿ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಅವ್ರು ಮಾಡ್ದಲ್ಲ ಇದ್ರೆ ಹಂಗ್ ಬರಲ್ಲ ಅನ್ಸುತ್ತೆ. ಅದ್ ಕೇಳ್ಕೊಳ್ಳಿ, ಮೈನ್ ಸೆಂಟರ್ ಕೇಳ್ಕೊಳ್ಳಿ, ಮೈನ್ ಸೆಂಟರ್ ಕೇಳ್ಕೊಳ್ಳಿ. ರಿಜಿಸ್ಟರ್ PH ಮುಂದೆ ಇದ್ದಿದ್ದು ನಮ್ ಮುಂದೆ ಲಿಸ್ಟ್ ಆಗಿದೆ, ಅದು ಟೆಂಪ್ಲೇಟ್ ಓಪನ್ ಆಗ್ತಿಲ್ಲ ಅಂತ ಮೈನ್ ಸೆಂಟರ್ ಕೇಳಿ, ಅವಾಗ ಅವರು ಸೆಟ್ರೇಟ್ ಮಾಡ್ಕೊಡ್ತಾರೆ ಏನಾದ್ರು ಇದ್ರೆ. ಸರ್ ಗೊತ್ತಿಲ್ಲ ಸರ್.
May I mention a matter, Milord?
On the list. All memos to the court officer.
For hearing on interlocutor.
Milords, the matter is on Monday before the executing court.
Let it be given
That's
to
with
the
your
court
lordship's
officer.
permission.
Cell number 1.
That's with your lordship's permission. Serial number 26. I'm filing a memo to withdraw the
Take that.
Right. So 26.
serial number 26.
26.
Memo is first thing to withdraw the petition. Memo is taken on record and dismissed as withdrawn. It's
Cell number
Please.
1.
With regard to serial number 1, Milord, that's one humble submission. We have engaged the senior counsel. As he hasn't turned up due to his personal inconvenience, beat on Monday, had together. Monday.
I will adjourn it on cause.
The
I will adjourn it on cause.
The matter, there is no urgency as such, Milord.
On the last
He has
occasion,
got preponed, he has
on the
got
last
preponed this matter,
occasion you have
humble
sought time.
submission. He has got preponed this matter by referring.
You can't have an interim order forever.
No, Monday, finally.
On cause. It's a matter, first matter listed in the list, and you seek for adjournment. I will not accommodate.
The day for yesterday I was submitting. Another suit is on.
I will
on
not hear
third
all
day.
that. I am not
August-
concerned about
August
any
3rd.
other facts.
Between the same
Matter
party, the
listed
same-
as item number 1, it should be argued. It should be argued.
Monday finally. But to the same.
You can't take the court so casually.
Correct. I do understand.
When there is item number
Monday
1 is
finally.
listed, you can't ask for time.
Because now senior counsel.
I'll vacate the interim order and I'll post this matter on Tuesday. List this matter on Tuesday, interim order is vacated.
No, my lord, by 2 to the other is mine. I will have one.
Yes, next matter.
By 2.
Number 2. Cell number 2.
I'm appealing for
Read out
petitioner
for
in this case.
petitioner.
Request this honorable court to complete it. To allow
Let that interim order be there. Monday as first case. Interim order granted is extended till then. Yes.
Kindly allow me to withdraw this.
Huh?
Kindly allow me to withdraw this case, Your Lordship.
Kindly along with
To withdraw this case, Your Lordship.
Memo for withdrawal. By
you that.
Challenging the order passed by the commercial court, Your Lordship.
The memo is fetching to withdraw the petition stating that the main commercial suit itself is disposed of, is decreed on 3/7/2026. Memo is taken on record and dismissed as withdrawn.
Cell number 3. Cell number 3. Shailesh,
I approve for the petition.
Hare for petitioner.
Your lordship, I seek for a short accommodation. Any date may be given.
Why it has come before this court?
It's a GM DRT matter before Justice Jyoti, and since we cannot appear before her,
it has been transferred to this court.
Yes, this is matter next week.
Much obliged.
Yes.
Cell number 4. Cell number 4.
For the petitioners in this case, my lords.
Raghavendra
My
K.
lords, the petitioners are the landlords, my lords. The respondent number 1 is the tenant, my lords. The rent is fixed as 2,15,000 per month, my lords. My lords, without paying the rents by the respondent, my lords, he has filed a suit for permanent injunction before the trial court, my lords. My lords, he has sought a prayer that not to evict him without due process of law. That is the prayer sought by him, my lords. My lords, after summons has been served, my lords, the landlords have filed a written statement by way of counterclaim and seeking the arrears of rents along with one application under section 151 of CPC for the arrears of rents by paying the court fee, my lords. My lords, after this hearing of the matter, my lords, the trial court was pleased to dismiss the IA number 1 filed by the tenant under order 39 rule 1 and 2. My lords, the application filed by the landlord under section 151 of CPC for arrears of rent that came to be allowed, my lords. My lords, after that, without paying the rents, my lords, the tenant dragging the matter before the trial court, my lords, he has filed another application for recall the same order passed by the trial court. That is appealable order, my lords, that cannot be questioned before the same court. Without filing any appeal before the higher court, my lords, he has filed the application for recall of that order, my lords. My lords, my respectful submission to your lordship, my lords, kindly, my lords, even till today 60 lakhs
What
arrears
the
of rent is
impugned
there.
order?
My lords,
What is the impugned order before
my lords,
the
I
court?
am my prayer before this honorable court, my lords, kindly give a direction to the trial court to dispose of the, because my lords, suit for injunction is infructuous now, my lords.
Concluding anything.
My lords, my respect, my lords,
Come to your prayer. Let's see.
your lordship may kindly come.
Hmm.
My lords, suit for permanent injunction now it will become infructuous, my lords. Only counterclaim is pending.
I number 3 under so and so,
Please, my lords.
3/1/2026 to be disposed of.
Disposed of and direction along with that, my lords. Consequently, issue direction to dispose of
I
the,
will not give any disposal to dispose of OS number 2956 or 2025. What is the great urgency?
my lords, 60 lakhs, my lords, 60 lakhs arrears of maintenance is there.
The
Arrears of
petition
rent is there, my lords.
Saying prayer.
And
Council in this.
I may
in this
permit-
petition.
my lords, I may permitted to make one submission, my lords. My lords, that IA number 3 has been filed, my lords, for dragging of the matter. Your lordship may kindly go through the order sheet produced by my lords.
The council, you have to make submissions which are legally, which the court can hear. 2025 suit, can there be a mandamus to the trial court?
My lords, my respectful submission.
I will dismiss the
Injunction-
whole writ petition if you waste even a 1 minute, Mr. Council.
My lords, yeah,
Please
permanent,
understand.
I will.
I number 3, the petition is filing a mandamus to dispose of I number 3, filed on 3/1/2026 and OS number 2956 of 2025. Considering the fact that the matter, the IA is filed in the year on 3/1/2026, there shall be a direction to the trial court to dispose of the same within a period of 4 weeks. As far as other prayer to dispose of voice number 2956 of 2025, which is pending on the file of the
7th additional, my lords, 7th additional city.
7th Additional City Civil and Session Judge at Bangalore, where matters are pending which are of the year 10 years old, and this court cannot issue a mandamus to the trial court to dispose of a matter of 2025, accordingly disposed.
At least as expeditiously as possible, my lords. Lords, as expeditiously as possible, my lords, because
I said I will recall this order also, if you again make one more submission, Mr.
Cell number 5.
Please be rational in making submissions. You can't, whatever your client feels, you
no,
can't
not
submit
like that, my
here.
lords, because this,
Can there be, have you seen the Supreme Court judgment?
he is paying.
Can the court ask the trial court to dispose of 2020, so mandamus.
Because, my lords, he is taking advantage, his suit itself is not maintainable, he is taking advantage of that, my lords. That is what my respectful submission, my lords. Because permanent injunction suit becomes infructuous, my
10
lords.
minutes you have taken for this.
No, not like that, my lords, because I am
Cause. If
for
you-
requesting your
if
lordship,
you
my lords.
Submit one word more, I will dismiss it with cause. Yes, next.
But I appear for petition, Lord. But this plaintiff's writ petition, Lord. Plaintiff had filed a suit for a injunction, Lord, and a mandatory injunction. But it's a case of the plaintiff that not 8 feet into 20 feet is the western side of the shoot schedule property. Yes, Lord.
For injunction.
Injunction.
What is the IA for?
Not IA for temporary injunction is been not allowed and injunction has been granted, directing the defendant to not to put up the construction, Lord.
Yes.
That order has been appealed before them, Lord, the MA court.
It is confirmed.
the MA court reversed the order passed by them, Lord.
Let's see the MA order, please.
Lord, MA, Lord, there is one point, Lord, during the pendency of the MA, Lord, the court, Lord, appoints a court commissioner to inspect the property.
The appellate court.
The appellate court, nobody makes an application to, Lord, appoint a court commissioner.
Let's see.
But the court commissioners, this thing, Lord, has been extracted.
Para number
Para
12.
19,
Para number 12.
12. Peruse the entire records in this case. The plaintiff basically filed the suit for permanent injunction and later included relief of mandatory injunction along with the year number 139, 1 and 2, restraining the defendant from interfering with the possession and enjoyment of the plaintiff over the social property, and also restraining the defendant from disposing the plaintiff from the social property, stating that the scheduled property bearing assessment number so and so, measuring 43 into 103 feet, situated at Gadaganakeri, Shalkapa Taluk, is belong to the plaintiff's family. The plaintiff's family is in peaceful possession and enjoyment of social property from 50 to 60 years. The plaintiff has acquired the same through a partition taken place between himself and family members. Out of 43 into 103 feet, there is a Mangalore tiled house measuring 46.43 feet. In the said house, the plaintiff, his wife, children and other family members have been residing from 20 years. And now also they are residing in the same house. About 15 days back, when the plaintiff went to marriage function of his relative at Bhadravati, at the time, the defendant trespassed into the social property and trying to put up a concern by encroaching the property of the plaintiff. But the plaintiff restrained the defendant with a great difficulty. Therefore, the plaintiff has filed a suit and present application, hence the praise to allow the application. On the other hand, defendant contended the social property situated within the jurisdiction of Shalokappa town. The same was purchased by his grandmother, namely Srimati Jalihala, in the 1983 from one Sri Basurajappa, son of Soins, under registered sale deed. Since then, the defendant and his family members are in peaceful possession and enjoyment of the social property. The said property measuring east to west to 24 feet, north to south, eastern side 60 feet and 40 feet on western side. There exists an old house in the said property, which shows in the sketch, and also existing a coconut trees and a toilet and a guava tree. The defendant is putting up the construction within his own property by leaving 6 inches towards eastern side, that is towards the property of the plaintiff from the compound wall, and 6 inches towards southern side. And he is putting up the construction measuring east to west 22 feet, north to south 21 feet. There is a compound wall in between the properties of the plaintiff and defendant, and the said compound wall separates the property of plaintiff and defendant. The defendant has not encroached the plaintiff's property, and he is not trying to interfere with the plaintiff's property. A compound wall measuring about 57 feet in length and 5 feet height exists between the plaintiff and defendant's property. The defendant is not trying to encroach the plaintiff's property. Since the plaintiff has obstructed the construction work of the defendant has already filed a caveat, hence prays to reject the application filed by the plaintiff. To prove his contention, the appellant's defendants has produced a copy of sale deed.
Had no objection for appointment of advocate commissioner.
Lord, we have objected, nobody has filed, neither the plaintiff nor the defendant.
He has appointed, that order was not questioned by you.
We have filed an objection to them, Lord, the court commissioner report. We have not filed.
Objection,
Court
I'm
suo moto is
asking.
appointed, not court has taken.
When an order is passed, that order is not assigned by you. So you were accepting that order of appointment of commissioner.
But the verbal consent, Lord, the court has taken. That is what
So
that
now
is
we
what
have
the
to
council.
consider the report, unfortunately.
No, Lord. My submission, Lord, the appellate court's jurisdiction is limited to, Lord, to consider whether the
But that you have.
original order
accepted
has been original order which has been passed is not legally tenable or not.
But why did you accept that?
But
Why
we
did
have
you-
not
why-
accepted, Lord.
Were you a consenting party to that?
No, we have not accepted, Lord. Generally, Lord, if Lord any party or a court suo moto can appoint, Lord, for court commissioner, Lord, it is to the trial court to adjudicate,
Or
Lord,
a
all those
court can
things.
appoint, you can also question.
Please, Lord.
If you are agreed.
Lord, it is a trial court to, Lord, adjudicate all those things.
Come to para 19.
Please, Lord. Lord, 19, it says that, Lord, the court commissioner filed a report, Lord, there is no encroachment. And the defendant is putting up the construction in his property. Well, Lord, may I take your lordship, Lord, trial court order, Lord, before going to, Lord, the reasoning of them, Lord, the first appellate court. First appellate court reasoning, Lord, based on, Lord, the court commissioner report. That we have filed an objection to them, Lord, the court commissioner report. That has been not considered. That has been left to there itself. And the impugned order has been passed, Lord. No evidence led on, Lord, the court commissioner report.
Please come. We'll consider the Submits that the trial court has granted injunction in favor of the plaintiff. When that was carried in appeal, the appellate court has appointed an advocate commissioner. Basing on the advocate commissioner's report, the present order is passed, whereby the order passed by the trial court is set aside. It is submitted that the exercise that is the exercise done by the appellate court is contrary to the scope of the appeal, and the appellate court cannot do such an exercise while hearing an application, by hearing a miscellaneous appeal, considering the submission of the land counsel for the petitioner. The order dated, the operation, the order, the order dated so and so is suspended until next date of hearing. The notice and the hand summons memo shall be filed by 28th of July, or else stay granted by this court. Stands vacated. Yes.
Cell number
July.
6. Vijay Kumar T.
Petition.
Yes.
My lord, order 3 rule 2 application came to be rejected, my lord.
Order.
Order 3 rule 2 application.
Hmm.
My lord, the petitioner herein, the son of the defendant number 1, the defendant number 1 has executed GPA in favor of the petitioner herein to prosecute the appeal and give evidence, my lord. That application came to be rejected, my lord. My lord, impugn order annexure G, my lord.
How can he depose on his behalf? What will be in his knowledge?
My lord, the suit for partition, my lord. My lord, due to age old and ill health,
Come to the order.
please. My lord, impugn order annexure G, my lord, operative portion, my lord, page number 37, my lord,
Let's read it from
Para
the
nine.
beginning part.
para 9. It is pertinent to note that there is no bar under order 3 rule 2 of CPC that even if a party appears through his counsel at the first instance and later if he executes GPA in favor of a person of his choice to prosecute his case on his behalf through the same counsel. In the present case, the defendant number 1 has stated that he is unable to attend the court due to his ill health, but the defendant number 1 or his GPA holder has not produced the medical document to show that the defendant number 1
Is
is.
permitted to take out hand summons. Then once the memo is filed, if the memo is filed by 11th of August, this matter on 12th August. Yes.
Cell number 7.
My lord, proceedings can be
Confusion.
based.
Yes.
Defendant writ petition. Suit for injunction was filed. There is a boundary dispute between the parties. I filed an application for appointment of the commissioner. Plaintiff has no objection for appointment of the commissioner. The trial court rejected the application.
Where is the order?
Kindly see the order at page 37, paragraph number 9.
Yes.
It does not refer to the no objection filed by the petitioner. Overall perusal of pleadings and the document available on record. It is relevant to note that the plaintiff has to establish case by adducing evidence and has to show his possession over the suitable property. Further, the plaintiff has to establish alleged infringement by the defendant. The burden is cast on the plaintiff to prove his case to the satisfaction of the court. As I already observed above, the burden is cast on the plaintiff to establish case. Be it to be noted that the defendants have not made out a proper or relevant grounds for allowing the application.
What is the stage?
So my submission application for
You are
there
the
is-
defendant.
I am the defendant. We are claiming both the parties are claiming under a registered document. There is a boundary dispute between the parties. Then PW1 during the cross examination admitted he has no objection for fixing the boundary as far as the plaintiff and the defendant is concerned. In an application was filed, your Lordship may kindly see page 31. He has no objection for fixing the boundaries. He has no objection to allow the application. In spite of it, the trial court rejected the application. Once or all, the dispute will be solved between the parties. Nothing remains for the suit.
Let him adduce the evidence. Let the plaintiff prove his case.
No, plaintiff is already examined before the trial court.
You also adduce your evidence.
And I suggested for appointment of the commissioner. He said no objection.
That can't be a ground. Then it becomes a precedent in every case. Yes, please come.
And this honorable court in a case where even before the trial, commencement of the trial, the commission can be appointed even in respect of the injunction suit itself. So my submission is the dispute between the parties only boundary dispute. And there is no dispute with regard to the extent and ownership is concerned. Then the boundary dispute is there and there is no prejudicial cause to the either of the party. And on the other hand, the plaintiff has no objection for appointment of the commissioner. When this being the case, my submission before the court is it is just and proper for the trial court to appoint the commissioner.
Use the evidence. Then if it is not, if the evidence available on record is not sufficient, then the court will look into that.
With that observation may be disposed of.
That I,
Please.
the I number 9 is filed for the defendant under order 6 rule 9 CPC to appoint the court commission to survey and measure the suit scheduled properties and submit a report. The court by order impugned has dismissed the said application. While this, right, no, this is the present petition is filed questioning an order passed on I number 9 in OS number 428 of 2015 by the First Regional Civil Judge in JMFC at Nelamangala dated 15 June 2026. The petition herein, who is the defendant in the suit, has filed the application under order 6 rule 9 CPC questioning of file an application order 6 rule 9 to appoint the court commission to survey and measure the suit scheduled property and submit a report. The court by order impugned has dismissed the application. While dismissing the application, the court has observed that the plaintiff has filed the suit for injunction. He has to succeed, or he has to adduce the evidence and has to prove his case. And at the request of defendants, the court commissioner cannot be appointed and accordingly dismiss the application. Next para. Plaintiff counsel appearing for the petitioner submits that when the old dispute between the parties is about a boundary dispute, when the defendant has no, when the plaintiff has no objection for appointment of the advocate commissioner, the court ought to have allowed the application and it would solve the dispute between the parties. But without doing so, the court had in a hypothetical manner had dismissed the application and the same needs to be set aside. Next for having with the counsel for the petitioner, there is a material on record. Petitioner is the defendant and the suit is for permanent injunction. When the plaintiff has come to the court seeking a particular relief, the burden lies on him to prove his case. The appointment of an advocate commissioner will come when the issue will come, when after the entire evidence is adduced before the court and basing on the said evidence, if it is not feasible for the court to decide the dispute between the parties, then the advocate commissioner can be appointed. But in this case, the said stage has not come and the court has rightly rejected the application. In that view of the matter, this court is passing the following order. The writ petition is that this court do not find any reasons to interfere with the order passed by the trial court, accordingly dismissed. Next, it is made clear that this will not preclude the parties from making an application for appointment of an advocate commissioner at an appropriate stage.
Then number 8. Siddaramaiah VP.
Appearing for petition.
Yes.
This writ petition is filed by the first defendant. Suit is for partition and separate position. The contention of the petitioner is item number 10 and 11 are purchased by the defendant number 1 after.
It is the present IA.
On the present IA, my lord, I have filed IA for amendment of written statement to
Yes.
take additional defense.
Suit is of which year?
My lord, in RA I have filed. In RA I have filed. RA is of the year 2020.
In RU you are the appellant.
RA I am the appellant.
You want to amend the your written statement?
Written statement by taking additional defense.
Let us see your affidavit.
Affidavit, my lord, at page number E is the IA. Affidavit,
Huh?
sorry, page number 88 is the IA. Page number 90 is the affidavit.
Let's
These are all
read
the
it.
amendment I have sought.
Let's read your affidavit.
Yes, please, madam. My lord, para number 3. I submit that the appeal is continuation of sound. Para number 4. It is submitted, respondent number 12 is included to appeal recently and the application filed by the first respondent before this honorable court. I submit before the court below, I could not able to raise defense which is now sought for insertion to my written statement due to ignorance, oversight and also due to lack of knowledge. I state the defense raised through the amendment application is an continuation of the defense pleaded earlier before the lower court and the same are not going to withdraw any of the admissions made earlier. On the other hand, the proposed amendment makes easy to solve the dispute between the parties effectively and completely. I stated, since I am not aware of the legal implication and proceedings, I could not able to.
Ultimately, you will not say what you want to say.
Yes.
You just say like, it will not, it is, or what is this affidavit?
So, my lord, the
So
prior,
whatever facts you want to plead by way of an amendment, when it came to your knowledge, what is it? That is what is the affidavit for, not for saying that on legal grounds. Come to what is that your, where is that IA?
my lord, IA is on page number 88.
Let's see.
Yes. Page number 88. Para 5A, I want to insert. The defendant submits the marriage of the Siddhananjamma, who is the mother of the plaintiff, and the Siddhalingamma, who is the mother of the defendant number 1 and 2, taken place earlier to enactment of Hindu Marriage Act 1955. Hence, it is valid marriage. It is submitted that defendant number 3 is the legitimate children.
In this regard, there was no pleading,
Yes.
there was no finding by
Yes.
the trial court.
Yes.
And altogether a different case you want to introduce by way of this amendment.
So second one is, my lord, is para 8A. It is a matter of limitation, my lord, under 110, it is barred by
Legal
limitation.
question.
Yes.
Then what about the land bearing so and so? First, you cannot, this defendant submits that marriage of so and so, it will, the entire nature of the suit will change now.
No, it's nature of the suit will not change, my lord, it's only partition, it is an additional defense that will
It's
be
not a-
taken by the
that is
defendant.
legal aspect.
Yes, please.
Somebody's rights have already been accrued by way in the suit. Now you say that they're not, it's a void marriage and all.
It's a continuation of original proceedings, my lord, under these
Please
circumstances, my
come to
right will be
the, come to the
affected.
impugned order.
Impugned order is at page number
Hmm.
106.
Yes.
105, it will start, my lord. 106 is the prior wickets, para number 7 is the reasoning.
Para 7.
Yes, page 106, para 7.
Hmm.
In para number 5 and 6, prior is extracted. Para number 7 is the finding. According to appellant, he was unable to raise the defense now proposed for inclusion in his written statement.
So you can come to straight away paragraph 12.
It is indisputable that it is held in the case of so and so, that appeal is considered as a continuation of the suit. Furthermore, the application seeking an amendment under Order 617 of CPC can be entertained under two specific circumstances. Firstly, the proposed amendment must be necessary for adjudication of the matter in controversy between the parties. Secondly, the party seeking the amendment must demonstrate that they could not have raised the issue before the commencement of the trial despite exercising due diligence. Under Order 617 of CPC, the court may permit either party to modify or amend their pleadings at any stage of the proceedings. This is allowed on terms that are deemed just, and all amendments should be made as necessary to address the actual questions in controversy between the parties. However, it is important to note that no application for amendment will be accepted once the trial has begun, unless the court determines that despite exercise of the due diligence, party could not have raised the issue before the trial commenced. Therefore, firstly, the court must consider that despite exercising due diligence, the appellant could not have raised the proposed amendment before the commencement of the trial in the original suit in case of so and so. So and so. Para 87, para number 9, 87. The law on due diligence developed till this date is summarized as and. Due diligence means careful and persistent
Has
application.
rightly considered all the aspects. Please come.
Yes, this is my.
Agreed with the orders passed in I number 4 and RA number 179 of 2020 by third edition district and session judge at Tumkur dated 20th June 2026. The appellant defendant is before this court. The respondent herein has filed a suit for partition that came to be decreed by judgment and decree dated decree dated 20th December 2019. In the pending RA, the present IA is filed seeking amendment of the pleadings. It is amendment of the written statement. It is a case of the, it is in the application accompanying the said IA. It is stated that since the petitioner, a defendant is not aware of the legal implication and proceedings, he could not able to differentiate himself in respect to the legal aspect. Now he learned that the defense stated in the proposed amendment is very much required to decide the dispute between the parties fully and completely. And also proposed amendment is in respect of the prevailing law, which rules and governs the parties as on today. By way of an amendment, is requesting and seeking leniency to insert the things as a position exists as per law and facts in the case on hand. And if the amendment is allowed, no prejudice would be caused to the plaintiff. When it comes to the amendment as sought, it is stated that he wants to add para number 5A. He want to add para 5A to para number 5, stating that the marriage of one Siddha Nanjamma, who is the mother of the plaintiff, and Siddha Lingamma, who is the mother of the defendant number 1 and 2, taken place earlier to enactment of the Hindu Marriage Act 1955. Hence, it is a valid marriage. Defendant number 3 is a illegitimate children as per section 16(3) of the Hindu Marriage Act and born of bigamous marriage, that is born in a void or voidable marriage. Hence, the defendant number 3 is not entitled for any share. Then he wants to add para 8A to say that the suit is barred by law of limitation. Then para number 9A, the plaintiff want to insert a prayer that, or insert the additional pleadings. He purchased the property under a sale deed dated 5/2/1998 for valuable consideration, enjoying the same exclusively by getting the separate entries. That expired. The trial court, by order impugned, had dismissed the application. The court had considered the scope of the Order 6 Rule 17, and having conscious of the fact that even at the appellate stage, that application can be allowed. The court has observed that in the affidavit it is stated that due to ignorance, these facts were not pleaded. The court observed that that doesn't amount to due diligence. Further, he also wants to clarify the current legal position. To clarify a current legal position, amendment of the pleadings is not required. That the question of law can be argued at any point of time and accordingly dismiss the petition. The learned counsel appearing for the next para learned counsel appearing for the petitioner submits that the court ought to have appreciated the reasons that are stated in the affidavit, and the said amendment is very much necessary to determine the dispute between the parties, and this aspect was not appreciated by the court, and the court had dismissed the same. Submitted that the order impugned needs to be set aside, and an opportunity shall be given to the petitioner to amend the written statement in the interest of justice. Next part. Having heard the counsel for the petitioner, peruse the material on record. After the amendment to Order 6 Rule 17, if the petitioner wants to, if any of the party wants to amend the pleadings, it is incumbent upon the party to aver and prove that in spite of due diligence, this particular amendment could not be brought to the notice, could not be made at an earliest point of time. Secondly, whenever an interlocutory application is filed, along with that, an IA affidavit is filed to state and to bring to the notice of the court what was the reason for filing such an IA and why that application could not be, in case of this, why this application could not be filed at an earliest point of time. This court has perused the affidavit that is filed, except stating that there is, because of ignorance, nothing has been stated. He is represented by an advocate. If these on these grounds, if the court starts entertaining amendment of pleadings, it is opening a Pandora box. In each case, whenever they want to amend the pleadings, they can plead the ignorance of law, which is not excusable, and the trial court has rightly dealt with it and rightly dismissed. And this court finds no reason. Next.
Cell number 9. Madhu H.E. Petitioner.
I'm for the petitioner. Petitioner is JDR number 3. The respondent number 1 filed a execution petition after lapse of 16 years, 10 months. Subsequently filed a IA number 1 condonation of delay 4 years, 10 months. The honorable trial court condoned the delay, my lord, that impugned order is
This
charged.
is,
Page number 9.
you have
Page
filed
number
one more writ petition, this Mahadeva.
connected, madam.
Where is that?
That yesterday it came before the court and stay was given, my lord,
Stay was granted.
granted.
Stay of execution is granted.
Sir?
Stay of execution was
Yes.
granted. So it's the same execution proceedings.
Same proceedings, my lord, the 2 IA. Another IA is maintainability.
Entire stay
Entire-
itself. List along with so and so. Notice. Yes, next.
Cell number 10. Sachin B.S.
Plaintiff's writ petition. Amendment of plaint application was rejected. Its application is filed at pre-trial stage. Pre-trial stage.
Suit is for,
Suit is for declaration that a sale deed which was executed by my father is not null and void, and for an injunction relief. Injunction relief. Correct. Lords, there are some clerical. Lords,
shall look at the affidavit that's filed
Yes.
by you.
Lords, kindly see my application. My lords will find it at page number 38.
38.
Yes. After the death of my father, originally the property is my father. After death of my father, the said property was inherited by the present plaintiff and my mother.
Let's read it.
Yes.
Read your affidavit.
Yes. Page 38.
39 or 38?
Yes. While drafting a plaint, in spite of due diligence, some mistakes were made in the seeking proper relief which requires to be corrected and to do full and complete justice. The amendments sought in the application are very much essential to seek proper prayers. The amendment will not change the character of suit, will bring the same new facts beyond the scope of suit. The amendments are essential to put a real dispute between the parties. Mistake made during the drafting and typing the plaint is due to.
Please come to that application.
Yes. Application, page 38, add new prayer after the prayer in the prayer column of the plaint as follows. For judgment and decree declaring that plaintiff is the joint owner of the suit property along with his mother, Sri Kusma Ganapati.
Now, please come to the order.
Order says that mother is not made as a party, therefore your application is not made. It's impugned order at page number 19, reasons.
So you say trial has commenced?
No, pre-trial stage.
Issues have been framed.
Issues framed, it was posted for evidence. Evidence has not yet been
So once
commenced.
the issues are framed, that is the commencement of trial.
Evidence is not yet been commenced.
No,
Even
but,
evidence.
when we speak about commencement of trial, that is framing of issues.
Just,
Then you say that when you are a joint owner along with your mother,
Yes.
the mother is a necessary party.
Party, correct. My lords, it's a curable defect. You can always get impleaded.
Huh?
Curable defect, I can get it impleaded. My mother.
Oh, first it should be implemented.
Yes, yes.
It
my
should have
lords
been
is
two
right.
applications
Yes, yes,
simultaneously.
Yes, my lords.
One under order 1 rule 10 and the
Correct.
other one this.
Yes. My lords, can I make a request of this? I have also instructed my client, my lords.
I'll adjourn this matter.
Yes, yes, yes.
This is matter in the month of August.
Great.
Cell number 11. Yes, first.
But I appear for the.
Ashiti.
Lord, I appear for the petitioner. Lord, the petitioner had filed a suit against the respondent 1 to 3. Lord, the plaint annexure A at page 12. Lord, prayer is, your lords may kindly appear.
Now, what is the present IA?
Lord, IA for the impleading application allowed by the trial court against the respondent number 4 and 5. Lord, has been challenged because we have sought, no relief has been sought against them.
Let's see the order.
Yes.
Where is the order?
That your lordship will, it starts from at the page page 70, not the,
Page
page 75.
Let's read from very short order from para 2 we'll read.
Para 2. The accompanying affidavit, it is submitted that proposed defendant 4 and 5 are in possession and enjoyment of the commercial building bearing number, door number.
Suit is for?
The suit is for not to prevent them from, that is what the page 16, your lordship may, the page 16 of the paper book. But I only sought again at the defendant, the respondent 1 and 2, not to prevent us from performing the pujas. May I read, when not page 16, the prayer, your lordship may. Lordship may got it.
Yes.
It, the plaint starts from annexure, page 12.
For a declaration that the
One
plaintiff
minute,
is
the melody for a permanent prohibitory injunction restraining the defendant, their men and the agent, anyone claiming through them under them for in any manner locking or interfering with the daily pujas, Vogas and periodical Gana Homa rituals of the temple situated in the plain scheduled property in any manner. That is against the respond.
But you also sought for a declaration that you are the absolute owner of the plain scheduled property. At
But
A,
the
page 15, A,
page 15.
bottom.
The, for a declaration that the plaintiff is absolute owner of the plain scheduled property.
That is prayer number 1.
The prayer number 1.
Yes.
Yes.
Second is the prohibitory injunction.
Prohibitory injunction.
Now please come to the order.
Yes. Not the so far as defendant, the respondent 4 and 5 who filed an application, they are a tenant under me.
I'll.
Yes,
once
yes, your
read the
lordship. I will
order,
read the melody. As per your lordship's direction, I will read it. Para 2, page 75. In the accompanying affidavit, it is submitted that the proposed defendants 4 and 5 are in possession and enjoyment of the commercial building bearing door number 8/19 and 8/16 situated in the suit schedule property bearing survey number 35/7 of the Pantaru village. The suit schedule property is a government land which is in B. Parambuku land. The revenue record stands in the name of the government. The plaintiff has no manner, right, title, interest over the suit schedule property. The plaintiff, colluding the defendant, filed the above suit and obtained a collusive decree and behind the back of the proposed defendants. There were proceedings in the WP number 9939 of 2020 before the Honorable High Court of Karnataka between the proposed defendant and the plaintiffs. The plaintiffs has filed a suit OS number 48 of 2025 against the proposed defendants before the civil judge and JMFC Moodvidre. That is not correct, not the anyway, that will read it. The proceeding before the Deputy Commissioner D.K. Mangalore in area number 17 of 2019 and 2020 is filed against the proposed defendant. The proposed defendant have filed the statement disputing the claim of the plaintiffs. The proposed defendant formed a trust dated 18/7/2019 for a permanent for the management of the Veerabhadra Swami temple situated in the portion of the suit schedule property. The proposed defendant are in possession of the portion of the suit schedule property since several decades. The plaintiff got created alleged will deeply purported to have been executed by the Sri Shanta Bai and illegally obtained the mutation. Subsequently, that said mutation was cancelled. The suppressing all the material facts and the plaintiff filed a collusive suit without impleading the proposed defendants. The proposed defendants are a proper and necessary party to the suit. Hence, they may be impleaded and a regular defendant. The above application is resisted by the plaintiff by filing an objection. In the objection, it was contended that the proposed defendants are in possession of the door number 8/16, 8/19 situated in survey number 35/7 of the Panthayar village at the tenant under the plaintiff. The plaintiff has already filed an eviction suit in SC number 66 of 23 and SC number 68 of 2023. In the said proceedings, the proposed defendant have taken a similar contention. The said contention was rejected by the dishonorable court by order dated 27/2/2025. In the application, proposed defendant never stated that how they have put into possession of the suit schedule property, through whom they got the possession of the suit schedule property. The plaintiff is an absolute, the owner of the suit schedule property by virtue of the sale certificate and will.
Yes, I've seen, I've gone through the
Yes.
order. Yes.
Lord, the defendant number, the 4 and 5 who filed an application, Lord, against them, there is I have filed a eviction suit against them. That is in the OS number 66 and 68. My lord, in that, they filed an application claiming that I am not the owner of the property. It is a government property. Then I have no right. But on the other hand, they have been a tenant from 1960, and one is one of the one 1960, another is 1990, and they have been paying a rent to earlier my aunt, father's sister. Thereafter, from 2003, they are paying a rent to me. Now I said it is a temple. The small portion given to them is in the portion of the one temple. But temple was in a dilapidated condition. Therefore, we asked them to vacate. Now they stopped paying it, but the rent paid by them, I have produced the document also. Now in a suit I have filed, they filed an IA saying that it is a government land, he has no right. But that the contention of them was rejected by the trial court in the IA filed by them. That order has been that the contention they rejected in for dismissal was that was rejected by the trial court. That order was confirmed by this honorable court.
In which case, in which suit they have filed it?
That your lordship may that is in the SC number. I have produced the order trial. Your lordship may.
That's what the eviction suit.
That is eviction suit at the page 42.
Eviction suit, what was their ground?
The ground will not, that premises is required by us, and that the buildings are very, old, and we have asked the tenant to vacate. That is 42 at the IA.
I understand. You
I'm
are
sorry.
saying what was the IA that was dismissed and confirmed by this court?
That is, the order is page 42, Annexure G. Your lordship, it will start from page 44. That will not that their IA.
That SC, that order on IA.
IA, yes, it is 44.
It is for want of jurisdiction. IA number 1.
Yes, the IA number 1 they filed. My SC, the eviction suit is not maintainable. That is
Want of jurisdiction.
Yes, there your lordship may the elaborately it was contained. The order was detailed order passed by the trial court in page 45 to 53. They have taken that it is a government property, and they are not the owner. They said this, then page your lordship may page 45. Your lordship may para 2. The accompanying memorandum of fact, council or different says there is a denial of the landlord and tenant relationship. The property is so and so and so. Then, my lord, thereafter, the page 45, the question of the title does not arise. Contention raised by the defendant stating that the subject property is a government land cannot be considered in the present suit.
No, this is on issue of jurisdiction. Nothing has been determined by the court.
Yes. Then, my lord, they filed the dismissal of that order was challenged before this honorable court.
That is confirmed. Is confirmed.
Yes.
Yes.
Now, my lord, in the present suit, I have because in respect of them, I have filed an eviction suit. It is a pending. The sum of I have filed an eviction petition about 12 to 13 persons. Then for the 3 persons concerned, there is an already order of eviction. This matter pending is there. Then, my lord, only with the view to delay it, they filed an IA. That was heard and rejected it. Then they filed the CRP before this honorable court. Then after hearing it, earlier they obtained a stay, then we filed an application. Then, my lord, may I pass on
Not necessary. All those.
Yes, I follow. Then, my lord, yes, I have filed a suit against the defendant, the respondent number 123, saying that declared because the government, my lord, the earlier kata has been throughout in the auntie's.
You are arguing on the merits of the matter.
No, I am not, my lord. I am only saying that I have not sought any relief against
That I understood.
Yes.
That's your first submission.
Yes, I have no relief has been sought against them. Therefore, their application is not maintainable in the light of the several judgments of in this court and Supreme Court.
Pass.
Yes.
Give all the judgments you are relying on at a go.
Yes, but I think I don't want to burden with you. Anyway, I'll place
Whatever
it.
you want.
I'll place it, my lord. Then your lordship may
Save
kindly
the
see.
time of the court.
Yes.
Yes, Kasturi, yes, it is This judgment is,
Your
in a suit for
Lordship. My
specific
lord,
performance.
the absolutely, I'm sorry, my lords.
Kasturi judgment is arising after a specific performance suit.
Yes, sir. Then on the other hand, they said, my lord, there is no relation. That has been rejected. They're referring, once you admitted a tenant, you cannot go back. That has been considered in IA, referring the Supreme Court judgment also. That your lordship will get it, the order of the trial court in the IA. The Supreme Court order has been referred by in that IA that was confirmed by this honorable court. That is your lordship, that was referred at page 49.
In which case?
Their suit, I have filed the eviction suit against them. Then they said, I am not a landlord, I have no right to do it. Then they said, the page 49, so they said, once you have been admitted, you have been paying a rent. Now you cannot be, say that they are not the owner. It is a matter to be, has to be gone into in the trial. That your lordship will get it at page 49 of the paper book. That is earlier order. They have the trial court in earlier case.
Yes. Yes.
Your lordship, para 13, my lord, at page 49. In this regard, it is deemed just and proper.
Understand, how is it relevant to the facts of this?
Beg your lordship?
How is it relevant? They have filed an application under order 1 rule 10.
Yes,
Whether they are necessary parties to your suit for declaration.
yes,
Where they are denying your title to the property in the earlier suit, in the other suit.
yes,
Whether
yes.
they are proper and necessary, that is what we have to look at.
Yes, my lord, yes, yes.
All these other, on a jurisdiction issue, what is
yes,
raised, what
yes.
is confirmed, they are not relevant.
Yes, yes, yes. My lord, I have not sought,
Yes, I understood your submission that they are not necessary parties.
I have
because-
not sought any relief against them.
Yes.
I have not sought a permanent injection or any injection against him. Therefore, in the light of the judgment of the Honorable Supreme Court, my lord, that your lordship, I have placed at Kasturi, my lord, the suit for the necessary party held, only the parties to the contract are the person, then the necessary party.
How will Kasturi judgment will apply to the? facts
Your
of
lordship,
your case?
kindly be seen, necessary party who, it was held, there must be a right to some relief against the such party in respect of the controversy involved in the proceedings. My lord, I am not seeking a declaration against them, I have not sought. Then your lordship may kindly see the judgment of this honorable court in, made available in the Vardhaman,
Yes.
the order 1 rule 10, question involved in a suit means questions the concerned party to the suit, not to the third party. A third party against whom no relief has sought, no order is made, is neither a necessary party or a proper party.
Yes.
Then, Lord, I think there are another or several other judgments.
Yes,
The
it is here.
that is the order made by this honorable court, my lord, by the Justice, His Lordship Justice Sridhar Rao.
You have given it, it is here.
Or then,
Pass on.
that honorable Justice Kudur's judgment also I have made available to your lordships.
No,
No,
that
that
also you
is,
please give.
yes. No, that is, this is the,
Take that.
then, my lord, I don't think there are other judgment.
Yes.
My respected submission, your lordship may kindly see it. I have not sought any relief against him. But I have not sought permanent injection against him at all.
This is the same submission, you are making it now 7th time.
I'm sorry, then, my lord, I
But
withdraw
I
it
understood,
subsequently.
please don't, you
Yes,
have to
yes.
understand. the
Yes,
court's
I
time is
understood.
also
I
important
understood
and,
it. I'm sorry, my
valuable.
lord.
Please
They-
come. I've heard,
Yeah.
yes. Agreed with orders passed in I number 10. In OS number 25 of 2024, dated 19/6/2026. The plaintiff is before this court. The petitioner herein, who is the plaintiff, has filed the suit seeking declaration of his title to the suit scheduled property. And also, where is the plaint?
Well, plaint, your lordship will get it at page 12 to,
Has sought a relief of declaration that the plaintiff is the absolute owner of the plain scheduled property and for permanent prohibitory injunction restraining the defendants, their men, servants, agents, or anyone claiming through or under them from in any way manner blocking or
May
interfering.
make one sentence, if your lordship permit me. There are 15 tenants are there. 3 tenants, there is an order of eviction. 2 has been filed. One more, one they will file application modify. I will only, you are sorry for interruption.
Blocking or interfering with the daily pujas, vinyogas, periodical gana homas, rituals of the temple situated in the plain scheduled properties in any manner. The present application is filed under Order 1 Rule 10 by the proposed applicants who wants to be impeded as defendants 4 and 5, stating that they are residing in the commercial property, which is in the suit scheduled property, as it is a government land, and they have been in occupation of the property. When the plaintiff herein has filed a suit for eviction, in that they have denied the title of the plaintiff and the landlord-tenant relationship, and it is their case that they have been deciding there in their independent individual capacity. When the defendants are denying the title of the, when the defendants have are denying the title of the plaintiff, and now the present suit is filed seeking declaration of his title to the property, according to the implead applicants, they are proper and necessary parties to the suit. That application came to be allowed by order impugned. While allowing the application, the trial court has observed that admittedly the plaintiff has filed the eviction suit against the proposed defendants and the same is pending for consideration. In the eviction suit, the proposed defendants have denied the title of the plaintiff and also denied the landlord-tenant relationship. Apart from the eviction suit, there were other proceedings, that is WP number 9939 of 2020 and another suit OS number 48 of 2025, and proceedings before the Deputy Commissioner in RAP number 17 of 2019-20.
But may I make one submission, because the other suit is nothing to with it 48. Then the RFA was, my name is.
I'm only recording what is written in this.
Sorry.
In all the above proceedings, the proposed defendant number 4 and 5 have contested the proceedings against the plaintiff. Under such circumstances, the proposed defendants cannot be considered as a stranger. The plaintiff himself admitted that the proposed defendants are in possession of the portion of the two scheduled property as tenants. On the other hand, the proposed defendants have denied the landlord-tenant relationship and they are claiming that they are in possession of the suit scheduled property not as a tenant under the plaintiff, but the suit scheduled property belongs to defendant number 3. The said contention of proposed defendants is to be adjudicated in an effective manner. In order to adjudicate the said disputed questions of fact, the presence of the proposed defendants is necessary. In the eviction proceedings, that's SC number 66 of 2023 and 68 of 2023, the question of title of the plaintiff may be incidental in issue. It will be proper to adjudicate the question of title in a comprehensive suit for declaration filed by the plaintiff. Under such circumstances, in order to adjudicate all the contentions of the parties, it is just and necessary to implead the proposed defendants in the present suit in order to avoid multiplicity of proceedings and divergent judicial findings, and accordingly, the IA is allowed. Next para. When counsel appearing for the petitioner plaintiff submits that he has not sought any relief against the defendants. The reliefs are against defendants number 1, 2, 3. When there is no, when the petitioner is not seeking any relief against the implead applicants, they are neither proper nor necessary parties to the proceedings. It is the submission of the land counsel for the petitioner that in the eviction suits, when they have denied the title and they have also filed an IA questioning the jurisdiction of the court, that came to be dismissed, and against that a writ petition is filed, and the order of the trial court is affirmed by this court in the writ petition. It is a case of it is further submitted that only with an intention to drag on the proceedings and to retain the portion of the property, they are coming up with one after the other proceedings. proceedings. And and the court has failed to consider all these aspects, and only on the ground that there are certain proceedings where both the parties are contesting the matters has allowed the application. It is submitted that in the present suit, no relief is sought against them, hence they are not a proper and necessary parties. Here, in this regard, he has relied on the judgment of the apex court in Kasturi versus E.M. Perumal and others, reported in 2005-6 SCC 733. He relied on a judgment of this court in case of Vardhaman Stankavisi Jain Sravak Sangh versus Chandra Kumar and another, arising out of dated 22nd March. This is by which court?
Beg your lordship.
This is by which court?
The-
This Vardhaman,
Karnataka High Court, but I think. The which your lordship, the judgment.
no citations, nothing.
No, your lordships are referring the order passed by the which.
No, this Vardhaman, before Narayan Rai Kudur.
That is not the,
No, to cite this.
this is an order of this honorable High Court.
No, that is true. We have to know from this which is the writ petition or which is the order, which is the case. Nothing. How can we refer to
Lord,
this?
I think, 1 minute. Lord, your lordship may kindly see the next page at it is reported in ILR,
That's not the one. Where is it?
page, the 889. 889.
90 of which year?
No,
You know that we cannot refer. Yes.
I'll
Then
give
he
the
has
correct.
relied on. And the
But
judgment
I'll,
of the Karnataka
it-
High Court in Srimati Kalavati Ratnakare,
but sometime what will happen? They
Versus
will
Srimati-
get out the,
Ambu Jamba,
but it's a Karnataka High Court.
reported in
judgment.
2001 to Karnataka Law Journal 262. Relying on these judgments, it is, and relying on these judgments, it is submitted that the petition is neither a proper nor a necessary party. And the court, without considering all these aspects, has allowed the petition. Next paragraph. Having heard the and counts for the petition per the material on record. The suit is one for declaration and also a mandatory injunction. As far as the issue, as far as the admitted fact in this case is, the implead applicant is in possession of the property and a suit is filed seeking eviction of the implead applicants. In the said suit, it is a consistent case of the defendants that the implead applicants, that the plaintiff in this suit is not the owner of the property, and they're setting up their own title to the property. In earlier proceedings, the eviction proceedings are pending consideration. When a declaratory suit is filed,
But I have produced the lease agreement before your lordships and rent paid also I have produced a document.
when the declaratory
Your lordship may kindly.
how can I consider all that in the?
But I only
declaratory
say, but I am
suit,
not
when
saying
an-
any
when an
relief.
IA is
I am
filed-
only whether he is not a necessary party because other proceedings
The
are. pending.
council, you have argued, I heard you at length, you
Sorry.
keep on interfering.
I am
can't
sorry, madam,
interfere.
I will not open my mouth.
What is that? When a suit for declaration is filed, when already in the pending proceedings, when a party is denying the title to the property and setting up his own title, he is definitely a proper and necessary party. As the court has rightly observed that even if the defendant files a suit and there is every scope for multiplicity of proceedings and for divergent judgments, if the petitioner is, if the implead party is simply, the applicant is impleaded in this case, the dispute between the parties can be amicably settled in a better manner, and is a proper party, but his presence is very much required to adjudicate the dispute of declaration. As far as the second relief is concerned, no doubt, the relief is not sought against these defendants have nothing to do with that. But as far as the main relief of declaration is concerned, for that, the implete applicants are proper and necessary parties. And the court has rightly allowed the application. When it comes, the petitioner has relied on certain judgments. The judgments cannot be, the Kasturi judgment is relating to a suit for specific performance. And all other judgments also, it all depends upon facts and circumstances of each case. And there cannot be uniform application of the precedents to every case. In that view of the matter, this court do not find any reasons to interfere, accordingly dismissed.
But I think it is not their case, their owner. Anyway, you
Yes,
will
next.
pass an order.
Next,
I'll,
Respondent 3 have taken notice, my lord.
yes.
3, my lord. Respondent
They have not issued notice.
Please.
Yes. Yes.
Council on KVT is not in station. Council on KVT is not in station, Your Lordship, today for the, when they have it on Monday, Your Lordship.
My lords,
What is urgent? Any urgency?
please, my lords.
What is urgent?
Injunction order, my lords. In view of the injunction order, my lords, they have taken the police protection and they are interfering with my peaceful possession, my lords.
Monday, Your Lordship.
We are in possession, my lords.
When was the order passed?
My lords,
Police protection order, when was it passed?
please, my lords. Recently, my lords. (16/4/2026), my lords.
How can you call it recent? This is matter on Wednesday. In the first list,
Please,
at the request of Land Council representing the caveator, it is made clear that no further adjournments will be granted. Yes.
For admission, cell number 13. Cell number 13, Syed Akbar Pasha.
But in this case, the council on record is filing memo for withdrawal of this writ petition.
A memo is filed stating that the petitioner is not interested to prosecute the matter and they want to withdraw the writ petition. Memo is taken on record and dismissed as withdrawn.
Cell number 14. 14 person C Aditya.
No representation on behalf of the party in person is this matter in the month of September. Yes, 15.
Cell number 15. KN Arvind.
For petitioner in the matter.
Yes.
The petitioner is the defendant number 5 in the suit, Your Honor. The respondent number 1 and 2 are the plaintiff in the suit. The rest of the respondent are the defendants in the suit.
What is the suit for?
Suit for partition that has been filed by the plaintiff.
What is IA?
The suit is that the claim is that the husband and the father
Forget
of
about
the
all that. What is IA?
IA for rejection of plaintiff. I have filed an IA for rejection of the plaintiff. The sale deed that has been executed by the
Please come to the application filed by you. Affidavit. Let's see, what did you say?
at the page number 30 for you. They are seeking for the partition of the property, which was sold by their father and their mother, father and their husband on 10/12/1981, for the petitioner's mother, Your Honor.
I will read. No, what is your specific ground in which paragraph?
It is in the paragraph number 4, that is page number 36. Your Honor. I said that the plaintiff here have sold the registered sale deed on 10/12/1981. They have been challenged. The said property was obtained on 25/5/1980 by the husband and by the husband of the plaintiff, Your Honor. And in turn, he has sold the said property on 10/12/1981. And they have challenged the said question the said party sale deed on 2024. The Honorable Apex Court was also held in AR 2025 SC 19.
Please come to the order, Impure. Come to the reasoning part.
In view of the foregoing decisions on the above point and findings of the thereon, I'll just go through. This is a suit for relief of partition and separate possession. That is page number 23. Your Honor. This is a suit is one for relief of partition and separate possession of the suit scheduled properties and to declare the sale deed of the year 1981 as not binding on the shares of the plaintiffs. The disputed question of the fact is such as that the suit is barred by law for the partial partition, and misjoinder of the parties cannot be ground to be rejected in the plaintiff. Time and again, it is held at the Honorable Supreme Court that the issue with regard to the limitation being mixed question of fact of law, and it is decided on the full-fledged trial.
Please come. When counsel for the petitioner submits that a sale deed of the year 1981 was questioned in the partition suit. Now, what will happen? You are a purchaser.
I'm a purchaser.
Come to the plaint. What is the prayer?
Prayer to affect the partition of the suit scheduled property.
Page number.
Page number 32.
Let's see. No, there, one of the prayer is sale deed dated 10/12/1981.
10/12/1981. Yes, sir.
Then what about the other reliefs?
They have not sought. They have not sought.
First relief is seeking partition.
Yes, Your Honor.
Second relief is
not binding, Your Honor. Seeking the sale deed as a not binding.
Yes. That's what I'm saying.
Yes, sir.
You are speaking about this sale deed and limitation. And what about the partition relief they are seeking?
They're just seeking the partition relief only on the suit scheduled property that was sold, only one property.
That is a part of the sale deed dated 10/12/1981.
Yes, Your Honor. Yes, Your Honor.
Is it correct?
Yes.
No, the partition that they are seeking is pertaining to the property which is there in the sale deed.
Yes, Your Honor. Which is there in the sale deed that was sold by the husband to the petitioner.
The parties, the plaintiffs are seeking seeking declaration of the seeking partition of the property which is part of the sale deed dated 10/12/1981, and also seeking a declaration that the sale deed dated 10/12/1981 is not binding on them. It is submitted that on the face of it, that's barred by limitation, and not necessarily in each case the question of limitation becomes a question of fact and law. It's submitted that the court has failed to consider all these aspects and dismiss the application. Considering the same, there shall be stay of all further proceedings. Notice to the respondents.
Notice to the respondent 3 to 4 may be dispensed as the claim is only against respondent number 1 and 2.
A memo is filed seeking dispensation of notice to respondents 3 and 4. Memo is taken on record and dismissed at the risk of. I've already granted seeking stay of at the risk of appellant, at the risk of the petitioner. No issue notice to respondent 1 and 2. Petition is permitted to take out hand summons and shall file a memo to that effect by 28 July, or else the stay granted by this court shall stand vacated.
Then number 16, Raghu MN.
My lord, I am defendant number 3 in the trial court. Here the petitioner suit for partition filed by my children against my father and my brother and my sister and my lord, I filed an application, IA number 7, order 7, rule 11A and D for rejection of plaint. Reason that the partition already taken place among the family members. It become a self-accord property after the partition. Therefore,
Is it your case or is it the case of the plaintiff?
it is the case of the plaintiff. They
That there
have
was
filed a-
earlier partition
Earlier partition, that document also produced before this honorable court, Annexure C, my lord.
by them.
By, they have filed.
That's what I'm saying.
And all-
Is it a document
Yes.
that is filed along with the plaint?
No, my lord, they have filed
Along with the plaint?
along with the plaint, but they are not sought for that, for a null and void or any, not binding anything.
Please come to the impugned order, let us see.
Impugned order, yes, my lord, Annexure A. The page number
Come to the
17 is
reasoning part, page 8, para 8.
para 8 of my lord, yes. Different number 3 is that there is a registered partition deed between him and different number 1 and 2, 1, 2 and 4 on 5/7/2021, registered on 6/7/2021. As on date of partition is affected, the suit item number 1, 2 property is separate property. Therefore, during his lifetime, the suit filed by the plaintiff is not maintainable. The learned counsel for the plaintiff argued that suit property acquired by Nanjundappa, who is the defendant number 1, is the father of the defendant number 3, is petitioner herein. He got the final decree in FDP 4 of 2000. He produced document number 4. His photocopy is the final decree is passed in FDP 4 of 2000. On perusal of document, it reveals that first defendant has acquired the suit properties and non-suit properties from his parents. Therefore, it was divided between the family members Muni Bhairappa, Timrayappa, Muni Rangappa, Muniamma, Kempamma and Muni Lakshmamma. And para 10.
Counsel for the petitioner submits
My lord,
the report without considering the application, that's fine.
the recent judgment.
Under order 7 to 11. When it is a specific case that already there is an earlier partition effected and it became the self-acquired property of the defendant. And in that case, during his lifetime, the plaintiffs cannot seek for partition of the property. It is submitted that the court has failed to consider all these aspects. Considering the same, there shall be stay of all further proceedings pursuant to the order dated. Notice to the respondent, same like in the other case, by 28th memo shall be filed or else a stay granted vacated. 17.
My lord, I filed a memo
David,
to dispense the notice to the respondent number 3 to 5, my lord.
Memo
And
is
I
filed seeking dispensation
stay the
of
further
notice to
proceeding, my lord. I
respondents.
sought in the stay. Much
I think I am loud enough to understand that I granted stay.
sorry, I'm not.
Yes.
Much obliged.
3 to 5, memo is filed seeking dispensation of notice to respondents 3 to 5. Accordingly, memo is taken on record and notice to so and so is dispensed with. Who are the remaining respondents?
The plaintiffs, my lord.
How many are there? 1 and 2?
1 and 2. Plaintiff.
Only 1 and 2 now.
1 and 2.
No, hand summons to counsel for respondent 1 and 2. Yes. Yes.
cell number 17, Kevin Narasimhan.
Proxy counsel for respondent. It may be taken up to be next week.
Why?
Senior inconvenience.
It has to be heard
Personal
finally.
inconvenience.
2 minutes. We have no interim order. It has come for admission.
Then we'll take it up on some other day. List this matter on 15th as a first case,
But may I request 16th?
16th as a first
Please.
case.
Cell number 18.
Great.
At the request of learned counsel, the respondent, no further adjournment will be granted.
Please. Great.
Yes.
Number 18. Yes, Prashant.
Pass over the matter, Lord. Senior
Who
counsel.
pass over? List
I'll
this
argue.
matter? No.
I'll argue.
Yes, argue.
Lord, the matter had come up, Lord, before this one, Lord, before the vacation.
No, what I'm not able to understand is,
Please, my Lord had directed,
what was questioned before the vacation court?
vacation court, my Lord. My Lord did not grant the interim order, orally directed them that if it is more than 15 crores, my Lord, we'll see. If it is less than 15 crores, my Lord, after the vacation, I'll have this matter as a part-heard matter. and then we will decide, my lord, is what orally my lord told. Thereafter, my lord, through the bank sources, my lord, I came to know that there are two bidders, and ultimately only one bidder turned up. In that view of the matter, my lord, I had to approach, my lord, the division bench, my lord. My lord, as on today, my lord, out of 4 properties, my lord, 2 properties are sold out.
Let's see, what did you say before the division bench?
Please, that is not along with the amendment application. I have filed, my lord, the interim order copy, my lord, dated, my lord, 2nd June 2026. My lord. Page 16.
Page?
Page 16, my lord. May I just read? Page 18, my lord,
Page 16 of what?
my lord, amendment application filed by me on 2nd June 2026. My lord.
In fact, it is culled out in my lord, when writ appeal got disposed
Writ appeal order also it is culled out.
That is culled out. Lord, order dated, my lord, kindly see, my lord, 29th June 2026, when writ appeal, my lord, got disposed of. Paragraph number, my lord, 2.
No, he's saying about some amendment petition that's not there in record.
Yeah, there is no consequences.
Only your objections are on record.
My objections are on record.
You have a copy of it?
Yes, I have.
Pass on.
My lord, the writ petition filed before this honorable court, stating that, my lord, I have given a one-time settlement offer of, my lord, 15 crore, wherein bank put one of the secured asset for a sale of rupees, my lord, 10 crore odd. That is, my lord, assailed before this honorable court. In fact, this honorable court, my lord, refused to grant an interim order. Said that let us see the outcome of the sale. In the meantime, my lord, in the vacation bench, they moved it. My lord, the order, my lord, passed by the learned, my lord, division bench before the vacation court, learned senior counsel appearing for the appellant, adverting to the one-time settlement proposal submitted by the appellants, would submitted that the appellant had offered a sum of.
Going into all that, you have conducted the auction. What was the price?
My lord, 10 crore 35, 35, I stated in my objection, 10 crore 35.
Then what is the difficulty to have a one-time settlement for 15
Three
crore?
other property.
Huh?
I have 3 other property. I can sell it. Out of the 2 property already I sold, there before the DRT. My lord, I not only this one secured asset, I have 3 more secured asset. I can sell it and I can.
No, what is outstanding?
My lord, 195 crore.
195
crore, which I indicate in the sale notice. My lord, kindly come to the sale
That
notice.
195 crores, how many properties are mortgaged?
I have total 5 property and 1 attached property. Out of that 1 property, I must be 1 or 2 property I already sold. 1 property which
When he
I,
is referring to a one-time settlement in respect of that property.
no, one-time settlement can be done either for a whole. My lord, I can't claim any more money, or I can't sell this any other property, or my lord, I have right to sell it in case after selling the.
For a one-time settlement of 195 crores, how can there be 15 crores be one-time
Please,
settlement?
please, my lord, may kindly take, my lord, their objection, my lord, page 19. Lord, loan is about 15 crores, my lord, which I took in 2013. And out of which, my lord, 3.5 crores, my lord, I have already paid. Page 19, my lord. These are the 4 properties, my lord, that are mortgaged by me. Page 19, my lord, of their objection.
Yes.
Lord, one, this 220/1, measuring about 38 guntas. Lord, this is the property involved in the present writ petition.
Which one?
220/1, page 19, Lord. 4
Yes,
properties.
220/1.
Please. 220/1. This is, my lord, the present writ petition. The second property, my lord, is 1244. It's a house property, my lord, in Sakar Nagar. That is already auctioned, my lord. And the third property, my lord, is, my lord, 134, my lord.
That is also auctioned.
That is not auctioned. In, my lord, this property initially was granted to me, my lord, by the government. It's an agricultural land. Initially, my lord, I mortgaged. Thereafter, my lord, government resumed the land, my lord, from me and took over, my lord, the property. They requested, my lord, for an alternative land. Instead of this property, my lord, I have given another property, my lord, 39/2. That property, my lord, they have already auctioned. This property also, my lord, they sought to auction in view of the fact, my lord, that as on today, the property is in the name of government. The whole auction process, my lord, is stayed, my lord, unconditionally, my lord, by the DRT. That property is not available to them.
Devanhalli village.
And the third property, that is also part of same lot, 134, 134, both. Alternative property 39/2 lot is already sold out by them. The Sakar Nagar house is already sold. 134 lot is as on today lot is a government land. 39/2 they have already sold out. The property which is as on today effectively remaining lot is only 220/1. They are selling it lot to 10.
No, but how do you expect the bank to accept a one-time proposal for 195 crores outstanding?
2022 lot, they only gave the proposal. But I'll just point out lot, from my writ petition 10 crores only lot. 2022.
COVID was going on.
Please.
COVID was going on. We given some offer. They are not complied. Which they are not complied. Now they can't seek a revival in view of.
No, we are not seeking. Please.
So anyhow, this OTS proposal and all, it is about the bank's policy. Why should we interfere? That is what the Honorable
Now,
Supreme
my
Court
lord,
said.
now, my lord, only one property is remaining. But I am ready to pay, my lord, more than what, my lord, the single bidder has offered. My lord, I am ready with, my lord, undertaking of
They
it.
have to accept your one-time proposal also. Then what will happen to the other?
134, my lord, is only the property which remains. That is a government land as on today. Unconditional stay, my lord, by the DRT is given.
No, not that it will never be stayed. Isn't it?
In fact,
No,
my lord,
no,
if
can the court say you accept one-time settlement for 15 lakh?
no,
And
they only directed.
I can understand this is the only property. When you're ready
That-
to pay 15 crores.
Effectively,
they're
that is the
selling
only
it-
property.
No, if when you're ready to pay 15 crores, they're selling it for 10 crores. Apart from this, if they succeed in this for the other 2 properties, they can sell it.
Not only against this property, my lord, 10.35 my lord, is the offer they got. I am ready with an undertaking affidavit and 10% DD, my lord, 1 crore 9 lakhs.
And what are the consequences that flow from that?
No, its sale is not so far confirmed. Not only bid they have received.
What will happen? I'm saying you pay 15 crores and will they release this property?
That is what, my lord, I am requesting. My lord. At least to that extent, if they consider, then the other property, my lord, it is already in DRT. My lord, we'll fight it out. My lord. It's a government land.
It's not so, my lord, I'll just point out. Now, as of now, my lord, 3 property, my lord, we put for auction. One is, my lord, the subject matter of this writ petition. However, my lord, auction purchase of paid entire money, we are not confirmed the order. We have, my lord, the matter pending before the division bench. And today the matter is listed today before this honorable court. And 2 more property, my friend is saying that some Goma land or that also we put for, my lord, auction. We have received the bid around, my lord, 15 crore rupees. One is, my lord, 11.07 crore. One is 4.446 crore. They came before this honorable court pursuant to this writ petition. After this writ petition.
No, forget about all that. Forget about the one-time settlement. Now, the highest bidder has quoted 10 crores and all. He's ready to pay 15 crores for
Only
the
to
same
release
property.
this property.
For the same property, not a one-time
Then
settlement.
my lord has to direct me in view of my lord Bhapna as well as my lord's held, my lord, some other case, my lord, if it is a beneficial for the bank, my lord, whether I am in the position to accept these submissions, my lord has to, because my lord held in one case.
Now, what happened to the sale? But there are interim orders.
In that case also there are interim orders.
In which case?
Which my lord, the one case Kavita Rajagopal, which I argued before the Honorable Court, where subsequently auction borrower paid my lord more money, which we wanted to accept it. Difficult is that.
Yes.
Annexure B, my lord, page 27. My lord, this was, my lord, as per their own request, my lord, and direction, my lord, we had given. Initially, it was 10 crores. We raised it to 12 crores. The bank officials, my lord, they themselves told.
The whole prayer before this court is with regard to the OTS proposal.
No, only with regard to this property, my lord.
It can't be because of the reason as rightly submitted by him. In fact, I have passed orders saying that when you conduct the auction and when you put the property to auction, you have to say, take that process to a logical end.
That was subject matter of a writ appeal, my lord, and subject to, my lord, the interim orders, my lord, it was to be confirmed. As on today, my lord, there is no confirm. Only a single bidder, my lord, participated. 10.10, my lord, was the, my lord, minimum price. And 10.35, my lord, he quoted, my lord. That is all, my lord. I am ready to pay, my lord. Other properties, my lord, I am 100% not sure that they will not be able to realize any money because it's, as on today, it's a government land. The other properties, my lord, they have already auctioned. As on today, my lord, 134, it's a government.
Come to your prayer.
Please. Prayer, my lord, page 21, my lord.
Yes.
Issue a writ of certiorari.
Quash the order dated 16/4/2026. What is this order? They refused for the one-time settlement.
This is, my lord, that rejection of, my lord, one-time settlement. And the second
So
prayer, my lord,
why should the court interfere with that? Is a question. That's the only thing.
my lord, we are offering, my lord, more than
In the light of the settled law.
But as on today, that is the only property, my lord, that is remaining.
Yes, Mr. Senior Counsel.
Lords, if your lords were to recollect your lords' memory, the reason why it was treated as heard in part was because we made a statement that there is only one property which they want to sell it at 10 crores. We said that we are offering 15 crores as a closure of the account, so there is only one property. Earlier also they had given one-time settlement. Of course, I did not comply with the same. Nonetheless, it is not in dispute that we are eligible for one-time settlement. Lords, what they did was, the bank itself issued a letter saying that if you give us an offer of 15 crores, we are going to process your one-time settlement. We had deposited 1.5 crores and pursuant to what they had indicated as the figure, we gave the request. After request is given, after some time they get back saying that, no, the authorities have not approved the same. This is the communication which came about. Then we said, all right, it is not something like a vague or an imaginary figure which you are required to spell out. You tell us. Now there is a formula which you will definitely have. You please tell us what is the amount which is required to be paid. We quote 15 crores because 10 crores, 11 crores, 12 crores was happened. They said, no, you give it at 15 crores. We gave it 15 crores. Now at least you tell us what is the amount which you are expecting for us to give to close this account as under the one-time settlement. I understand it's a commercial decision. At the same time, this is something which is non-discriminatory in nature. That is the view which has been taken in Sardar Associates case. At least if they tell, if your lords were to see the orders passed by your lords on the first hearing date, they had to indicate as to what is the amount which is the amount for which they will be satisfied to close this account as a one-time settlement.
What they say is there are other properties available.
Lords,
It's not the only property.
That is the reason why I said, Lords, I started with the prelude saying that they said we are going to close this account at 15 crores. We gave that offer of 15 crores did not come from me because they said we will close this account at 15 crores. We gave that account.
Transpired. Now they say that they are not ready for that.
Lords, now so far as the other property is concerned, which they are saying there are two contentions. Of course, that's subject matter of a matter. What happened was this property had been mortgaged. Then the government said it is a part of a larger part of Gomal, and they entered the name of government in the revenue records. The bank said we can't continue with your loan facility with this existing property. You will have to change this. So what we did is, instead of the property for which the government's name had been entered into the revenue records, we offered them a second property. Now that is property bearing survey number 39/2. So now that property they have sold and appropriated it. One house property was there that is also sold and appropriated. So there were three properties which were offered. Now, what they are doing is, at the time when we had given them this property, that is the government, the property for which the government's name is entered, we had given them some documents. The letter was issued to us saying that in lieu of that property, we are taking another property. The letter was already given. So it is in that light, Milords, there is no property available other than this property. That's a matter which is now before the DRAT. DRAT, Milords, as a matter of fact, when the hearing took place, asked, it's a government property, why are you auctioning this property? Unless these rights are decided. And this is a property which we are stating, Milord, that this is a property which was given in lieu of the other property. Not that we had mortgaged 4 properties. We had only mortgaged 3 properties.
So question the auction that had taken place before the DRT. So that
Milords,
it will all-
DRAT, Milords, I'm sorry, DRT Chennai is dealing with the matter where the other property, they want to bring it for auction, it's done. Now your lordships only wanted to know, Milords, the reason why your lordships, because if your lordships were to recollect, Milords, I said, let them not accept an offer below 15 crores, because I am offering 15 crores. Now, even when the matter came before the division bench, even the division bench suggested, if I am ready to pay this money, let's say something like this, they want to give away the rights of mortgage over this property at 10.5 crores.
No, then where is the question of OTS? How can the
Milords,
court
I'm
compel
making
them-
a statement beyond that, Milords. They want to sell this property at 10.5 crores, at which rate they are ready to give the mortgage rights in respect of this property. I'll give you 11 crores. I'll give you 12 crores. Give me my property. What more can I offer, Milords? The division bench asked the same question. Are you ready? I'm ready to offer this money. If the bank wants to forego the mortgage at 10 crores, 10.5 crores, can't they forego this property at 12 crores in my favor? I'll offer 12 crores right now.
Then what will happen to the judgments of the Supreme Court with regard to issuance of auction
Milords,
notices?
now the valuation is concerned, Milord. That's the reason why I said the valuation is concerned. After all these things, Supreme Court up to Bafna's case said that no, the right of. Then came the subsequent judgment that Shanmugal Velu's case, that where they said that this is only when the sale is notified and concurs into an auction, and the auction takes place. But wherever the auction is not taking place, then again the right to redeem revives. That's essentially what the Supreme Court says.
There is auction has taken place.
Lord's
and
auction, Lord's one statement which was made really baffles me is, a statement was made saying that we have already taken the money. The entire 10 crores, they have taken it from the auction purchaser. I asked this question to myself, if there is no confirmation of sale, where is the authorization for the bank to collect the money under Rule 94 and 95 of the security interest rules? Milords, most of these things, that's the reason why I said, Milords, there is lot more happens in these kind of auctions than what is said. Everything is assessed on the basis of the plain records and the compliance with the plain requirements under the law. Milords, when I am saying that I am going to pay you 12 crores, 1.5 crores more than what is required to be recovered by you from that property, why do you want to hold on to that property, to that purchaser?
No, does the act or any law says that once the auction is conducted, again, because the the borrower is ready to pay the money, so that the auction should not be taken forward and the money what is offered by the borrower should be accepted. Is it the way the
Milords,
auction goes on?
The matter, that's the reason why I said, Milords, this is a very serious issue where if the bank says that the security interest rights.
15 crores, what you are referring to all through was about a one-time settlement.
Milords, that's the reason why I said, Milords, now.
Where is this question has come ever?
Milords, this
With
is
regard
what,
to this property and
this
this
is what
amount.
fell from the division bench, Milords. When the matter came up, the division bench asked me whether I am ready to pay this. I said that yes. In fact, we had prepared an affidavit saying that we'll pay this money. If you are ready to forego the security interest at 10 crores, when I offer 12 crores, it is your commercial decision, you can take it. Common commercial sense requires that the bank has to take more money than
What
a
will
lesser
happen to
money.
the earlier judgments of the Supreme Court on this point?
Lord, so far as the judgments
Your right
Lord,
of redemption.
right
of redemption.
Lord, that's the reason, Lords. There are two things. One is my right, and the other one is the commercial rights of the bank. Until and unless a sale is confirmed, the auction purchaser doesn't get a right to say that no, I am entitled, because there is a requirement of a confirmation. Now, if the confirmation doesn't take place in the meantime, if somebody makes an offer saying that this is what the bank, Milords, in its common commercial sense can definitely say, or should definitely say that if I am going to get only 10.5 crores, instead I'll take 10 crores. The bank is enriched by 1.5 crores. You may shunt me out saying that you may not have a right to claim this. At the same time, the bank, when it is getting a better offer, at which rate this security interest would be compromised.
195 crores.
Pardon me, Lords.
Outstanding dues are 195.
Lords, the dues outstanding at 95 crores, whatever they are now submitting.
195.
Lords, whatever be the amount that is outstanding, it is dependent on the security interest which is available with the bank. Now, every one-time settlement, Lords, for me to be entitled to one-time settlement, if the total liability is,
How come the bank has granted this much of loan to you?
Lords, what
without
happens?
there being a security
Lords, these were the kind of loans which were granted based on the business prospects, the balance sheets of the company, and the secured assets. So collectively and cumulatively, an assessment will be made for the purpose of advancing the loan. Lords, there are many cases where the business have gone awry or that the business could not take off. Lords, now as a businessman, I will not wish to forego the properties, which is the only properties. I have lost in the business. I don't want to lose the properties. At least if I want to save the properties, a man in distress should not be put into further distress. That's what Mahakal Automobiles case said. I'm sorry, Lords.
Yes, Lord. As of now, there are 3 property I put for auction. One is this subject matter of this writ petition, and 2 more property in survey number, my lord,
39 bar
134. Also, my lord, I put the property for auction because there is no stay for me to, my lord, conduct the auction for recovery of money. That issue, my lord, came before this honorable court in, my lord, coordinate bench of this honorable court, and this very same contention in respect of that property, which is, my lord, before DR18. That point of time, it took a consistent stand saying that whatever, my lord, Gomala land and other things, my lord, no point of time we are communicated, and therefore this honorable court refused to entertain and pass a detailed order. I'll just place before this honorable court and said that you go before the DRT. And my lord, that order, I'll just show it. I have a copy.
DRT order copy. Yeah. Copy.
Subsequent to that, my lord, they gone before the DR80 and DR80, my lord, protected their interest in respect of subsequent sale, not this sale. My lord, now I'll ask myself, my lord, one question. For example, my lord, now as of now, I have 30 crore rupees security wherein I conducted the auction. One is this, and my lord, other property which I sold it for, my lord, 11.07 crore, and one more for 4.47 crore, and one more property before the, my lord, DRT, its attachment, my lord, approximately 30 crore. Apart from this, 30 crore, my lord, at any time I will recover. My lord, I can attach their other properties which is not secured asset to me. My lord, merely, my lord, that security asset is, my lord, only 30 crore. It is doesn't mean that, my lord, I am entitled if they are entitled for OTS for 30 crore rupees. That is, my lord, one, my lord, respectful submission. Second, it's not the first petition. My lord, kindly see the, my lord, series of petition in earlier. All the things, my lord, I placed before this honorable court statement of. Every time, some or the other way, my lord, this honorable court protected their interest subject to deposit of money which they are not compliant. It's not disputed facts. And, my lord, they're not, my lord, gone before the DRT at all. Once they gone before, my lord, challenge the, they suffered an order. DRT said, yes, your mortgage is right, your 13.2 is right, your, my lord, 13.4 is right, my lord, held in my favor. That is, my lord, not, my lord, challenge before the any forum. No, my lord, after all those things, coming to this honorable court and challenging the sale notice, my lord, kindly see the prayer which sought before this. One is, my lord, consider the one-time settlement offer. My lord, in view of, my lord, the honorable FX court in the case of, my lord, State Bank of India versus, my lord, Arvind Electricals, my lord, it cannot be a matter of right for the any borrower. In fact, we are given 2013 loan. We are given sufficient opportunity. We are given one-time settlement offer, which is they are not complied. Now, my lord, in this juncture, after selling the property, 3 property, my lord, which I already sold, my lord, auction purchaser paid the money. My lord, out of 3 property, 1 property, my lord, auction purchaser completely paid. I am not confirmed the sale. And 2 property, my lord, in fact, I am not confirmed the sale also. I am not taken remaining money in view of the DR80 order. Now, my lord, in this juncture, coming to this honorable court and stating that, my lord, I will redeem the property. My lord, this honorable court as well as, my lord, the honorable FX court. Once, my lord, I sold the property. 13.8, my lord, is a bad. Even though I want, in fact, one case, my lord is, we were all before my lords, and my lord had no, in that case also, my lord, only 25% of the money paid. Here, my lord, 100% of the money which is paid, however, I am not confirmed the sale. But in this juncture, my lord, redemption may not be, my lord, unless the bank may not be able to exercise, my lord, redemption or whatever, my lord, giving back the property. And apart from that, the conduct is also, my lord, matter here. I produce, my lord, kindly see the order which I, earlier all the judgments are, my lord, order passed by this one. Every time they relegate the matter before the DRT. Why? Before that, my lord, they can go before DRT, and subsequent to this, my lord, when I issued a sale notice, they can go before DRT. Why not in this matter? Therefore, my respectful submission, the prayer alone, the prayer which is sought before this honorable court, my lord, ought to, my lord, have gone before the DRT in the section 17 and not before this.
Yes.
Can I just say this, my lords? Your lordships may note the submission which has been made that they have collected the full amount of the auction price. As on the date of the auction, there was an interim order which was operating till yesterday, that the sale shall not be confirmed if it is for less than 15 crores. They wanted to sell this property at 10 crores, 10.2 crores is the price at which they want to bring the hammer down. Now, if the bank says that we have collected the money, there is something more than what the eye meets. Bank was not entitled to collect it. Lords may kindly have a look at Rule 9(4), my lords, of the security interest rules.
Yes.
Why should the bank be so proactive in collecting the money, notwithstanding the orders of the court? Not because if we are speaking about conduct, borrowers, my lords, conduct can always be pointed out because we are defaulters.
No,
We have failed.
No, the auction purchaser also has to be a party to this writ petition.
I will make them as a party, my lords. I'll make them as a party. Because if the confirmation is not taken place, then the question of auction purchaser being.
Taken all the entire money of 10
My lords, that's the reason why I said, my lords, where is any question of bank collecting entire money, my lords?
Inform the auction purchaser about the pending
The
litigation.
interim order can't go on, my lord. This honorable court refuses to grant an interim order. In fact, my lord, the honorable.
I'm asking you, have you informed
Inform the auction purchaser.
I'm not informed because we
Oh,
are
is
not.
it not your duty
Because I'm
to
not
inform?
confirmed the auction. On his own, he paid the money.
No. When the auction, when the notification is issued on the date of auction, by the time there are interim orders by this court.
There is no interim order.
Or your
Can you see
undertaking
there is no
before
interim
the
order when I
court.
conducted the auction?
Or your undertaking before the court.
Let him get the dates
I
properly.
just point out, my lord, this
Yes.
honorable court.
When was the auction conducted?
Please, my lord.
5.5 is the interim order, 8.5 is the auction.
The sale conducted on, my lord, 8/5/2026.
When was the interim order?
5.5.
Whether this order is communicated to me?
Of course, my lords,
I'll-
same date. It's communicated on the same date, 5.5.
My lord, in view of the whatever.
But they can, as he wants to get instructions, if the bank is
I'll just
communicated,
read-
he
I'll
can
just-
get
I'll
instructions,
just
no
read the order
difficulty.
passed by the division bench before the vacation. I'll just point out, my lord. My lord, kindly come to, my lord, paragraph number 2 of the writ appeal.
Where is that?
My lord, in the disposal order dated 29 June 2026. In writ appeal number 1382 of 2026.
No, where from I have to see those orders?
They produced it. In fact,
My lords, this is
petition
produced.
it.
ನೀವೇ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ, petition is produced it and made in advance.
ಇದು.
In this compilation?
My lords, in the compilation filed by the bank, which is a statement of objection stated
That is I'm not produced.
in the amendment application also.
At page 18 it is there. Page 18 of.
Page 97, Mr. Shetty has also
sorry,
produced it.
page
Page
18.
number 96, it is produced.
Yes.
In which it's the same order. There are no two
Otherwise, my lord,
different
I'll point out, my
orders.
lord, writ appeal order, my final order. I'll just.
No, I'm looking at
Same
the
thing.
initial order of 5/5/2026.
That is in para 2 of the final orders, my lords, which is extracted. Can I pursue your lords? May I kindly take the statement of objections filed by. ಇದೆ ಅಲ್ವಾ ನೀವು ರೆಫರ್ ಮಾಡ್ತಿರೋದು?
No, I'm referring the final order passed by the in the writ appeal.
ಇದೇನೆ.
Page number 97.
Page number 97, ನಿಮ್ಮ compilation ಅಲ್ಲಿ.
Please, my lord, I'm so sorry.
In
My lord, I'll
Mr.
just
Shetty's
read,
compilation, it is there at page
Page
96.
number 98, my lord, I'll just read paragraph number 2. Interim order passed by the vacation court on 5/5/2026, set out below. Learned senior counsel appealing for the appellant advertising to the one-time settlement proposal submitted by the appellant would submit that the appellant had offered a sum of rupees 15 crore and in order to demonstrate their bona fide have also deposited demand draft rupees 1.50 crore. The said pack evidenced annexure A produced along with the appeal. The primary grievance of the appellant is that during the subsistence of the negotiations under one-time settlement scheme, the respondent number 1 bank has proceeded to issue an auction sale notice by fixing the reserve price of 10 crore 10,86,000. Learned senior counsel would contended that the fixation of such reserve price is wholly arbitrary and runs contrary to the offer made by the appellants under the OTS proposal, which is substantially higher. Now let's say ex parte order. Prima facie, the court finds that the appellant have made out a case indicating that the reserve price fixed by the respondent by one sale of the secured asset is significantly lower than the amount offered under the OTS proposal. While this court is inclined to stay the auction proceedings at this stage, it is however deemed appropriate to safeguard the interest of the appellant by directing the sale. It conducted sale not be confirmed in the event of the highest bid. I'm not confirmed on it. Received is less than the amount offered by the appellant as under OTS scheme. issue emerges so and so. Paragraph number 3, my lord, the learned counsel for the response submits that response sale was conducted on 8/5/2026 and sale certificate, my lord, it's not correct. Sale
Not
certificate
correct.
was not issued. In fact, order passed by the it is also contained respondent appellant have no right to redeem the mortgage under sale. Sale certificate has been issued and however the sale has not been confirmed. In fact, sale is not confirmed and there is sale certificate also, there is no question of issuing. Without going into the other questions involved in the present case.
I've seen that order. I've read that
So,
order.
my lord, my respectful submission. We have not confirmed the sale. Till today, my lord, we have not confirmed.
Precisely your submission is, the auction, the highest bid was 10 crores.
10 crore, my lord, 35 lakh odd I passed.
35 lakhs. They are ready to pay 15 crores.
15
As far
crore
as-
to redeem this property.
Only this property.
12 crores to redeem this property, we will pay it. Not, they want to negotiate at
I will
10.36 crores.
beneficiary. I will void up I vote with all my lord litigation. But the problem is, my lord, in view of the Bafna as well as my lord this honorable court in the Kavita Rajgopalan, how to my lord answer the auction purchaser?
Lord, they have not even informed the auction purchaser that this interim order is
In
passed.
that case, also auction purchaser never informed.
No, but that's your duty. That's what I said. So in
Known
one of the
encumbrances,
judgments,
known orders should
there
be
is an
intimated.
obligation on the part of the bank to inform the auction, persons who are participating in the auction about the pending litigation.
My
How
lord-
can you just like sell the properties?
I'll just put it in this way.
And they would take the risk.
My lord, as of today, I am not confirmed. They must be aware. If they would have, otherwise they would have come to the bank and they would have asked.
You have the responsibility. There is no question of they might be.
My lord,
or they
have
may
it, my
be
lord, tomorrow, then my lord, I'll inform the auction purchaser today itself. The difficulty is this.
Please wait. Inform the auction purchaser. Let him come. Let him come before. In the meantime, by Monday, they should file the application,
Yes.
pleading them. I'll take up
My
this
lord,
matter on
the difficulty
Tuesday.
is, my lord, 2030, my lord, one of the old account NPA, I have received, I'm supposed to receive some money and my lord, I can issue a sales certificate. No point of time, they're not completed an interim order, except saying that I'm going to pay.
This will not speeden up the process, Mr. Bird.
My lord, then my lord, interim order should not be extended. My lord, I'll inform the auction purchaser, subject outcome of this.
What were you
petition.
doing when the interim order is granted by the division bench in the month?
Then my lord, I appeared before I just ex parte order. Immediate after ex parte, my lord, I filed an application.
that
I
was
pointed out,
happening.
I sold the property.
It granted on 5th to 6th of March, the 6th of June, 7th of July. It is
Lord,
subsisting.
Immediately, my lord, court got reopened. My
2
lord, I
months.
filed an application before the division bench. I pointed out, sale already took and interim order can't
No, I
extend it.
wanted to
Because
pass
of
some
that,
order. Please understand. I wanted to pass some order. Having known the fact that already the auction was conducted, some rights have accrued in favor of some party. Can I do it without
of it,
notice to them?
on the
And
face of it,
and
it
at the
is not
same
maintainable,
time,
Lord.
at the same time, the interim order that is subsisting from the last 2 months, why should it be vacated
Lord,
now?
on the face, my lord, I'll point out before this on the face of it, my lord, the interim order, my lord, the rift is not maintainable. In fact, I filed a
The respondent, it is submitted that the auction is conducted and the entire amount of 10 crores is paid. Then the senior counsel appearing for the petitioner submits that the petitioner is ready to pay an amount of rupees 15 crores.
to redeem this property. It may be recorded.
Lords, 12 crores to redeem this property. Lords, they are getting 1.5 crores more. 15 is what he has, 12 crores to redeem this property.
12 crores to redeem this property without insisting for the OTS, without going into the.
Without going into the question of OTS.
Timeline also let him indicate, my lord, when in
I'm
case,
while filing.
if the court agree, if they're able to convince the court, let him indicate a timeline.
Certainly.
I have money ready money.
In case if the court grants an order, they will pay the amount by. No further time I'll grant.
Not at all.
The moment the order is passed, the next day you'll be depositing. If that is the case, then only. You had enough
Lords,
time.
they have 90 days time to deposit, Lords.
No, that
Lords
we
may
will
extend,
not go.
not,
That we will not
Lords
go
may
into.
not. I will definitely prevail upon them, Lords. Lords may pass an order, I'll prevail upon them and then issue that is
No,
done.
I will fix the time frame also.
Please, my Lords.
What is the
Lords may
time
fix the
frame?
time frame.
Time
Lords,
frame, not 90 days.
Your Lords may fix 45
But you have
days.
been saying OTS
Lords,
proposal.
Lords,
from the
can I
last,
suggest this, my
last
Lords?
4 months.
No, can I suggest this, my Lords? Lords may fix 45 days with a rider that if I don't pay the money,
No,
1 minute.
no,
Lords, I'll just say this, with a rider that,
To show your bona fides, you should come up with the DD. That's the only ground on which the order will be passed. Or else, I will say, this is not.
I
the-
understand, my Lords. Lords,
only
if
I will- I
this
will
is the
relegate-
extent.
I will relegate you to avail
I
the
understand, my
appropriate
Lords.
remedies. So,
This-
this matter will come up on Wednesday.
Lords may fix a date within 2 weeks. If I don't come up with the DD, Lords may relegate me back, my Lords.
List this matter on Wednesday.
Please.
By the time the petitioner shall file an IA.
I'll inform, I'll
List this
undertake,
matter on,
I'll undertake, I'll inform the my auction purchase. Then no need, my lord, otherwise one more adjournment will be
No,
sought.
please
before this one.
understand,
Of-
I'm saying
Why?
Monday, Wednesday, why are you so in a
I-
hurry, Mr. Vignesh Shetty?
This, Lords, these kind of sales will have some internal
By
adjustments,
Monday-
otherwise.
By Monday, an application shall be filed, impleading the auction purchaser.
Details I don't have, my lords. I'll have to
Little-
see.
The learned counsel, Mr. Vignesh Shetty shall for the respondent, shall furnish the same to the counsel for the petitioner. And at the same time, the counsel for the respondent bank shall intimate the same to the party, to the auction purchaser, that the matter is coming up on Monday. And
Wednesday.
thereafter, I will take it up on Wednesday. And by Wednesday, if as per the proposal stated by as submitted before this court by the learned senior counsel, if to show their bona fides, they shall come up with the DD. Basing
Some
on
payment, my lords. Your lordships may say, there's
We
lords,
come up with a
humanly
DD.
impossible for me to generate.
Basing on that,
Please,
the court will pass further orders.
Please, my lords. I'm so grateful for your lordships.
The time, my lord, is not.
Interim order is,
The time is. my
and
lord,
you can't ask anything beyond this, Mr. Shetty. Yes.
Grateful, my lords.
Huh? Monday in the first list.
Sale number 19.
I appear for appellants.
List it as a first matter on Monday. Yes.
Sale number 19, Chandrasekhar Reddy.
For the respondent, sir. The appellant herein filed application
Madam, why
under
is it
7 to 11.
I'm having the roster 23 from 23. Why is CRPF 22 is listed? So only repetitions. Yes. Yes, what did you
Calling
want?
for
You are
TCR is
ready?
not required. in
Any
this.
urgency?
I'm ready.
Oh, any urgency in this matter? Any interim
Yes,
order,
madam.
sir?
Interim order.
No interim order, ma'am.
No interim order.
There is no interim
Well,
order.
This is matter in the month of August. Registry
Interim order may
shall
be
make
extended.
sure that the TCR,
Interim order is there, madam.
Number 20.
look at it.
Interim order is there.
Lord, I'm actually sailing with the petitioners, Lord.
Look at
Interim
the
order is
file,
there.
whether interim order is there.
Is there.
Yes, listed in the month of August.
Very
Interim
Right,
order
right.
earlier granted is
At
extended.
least
Yes,
next
20.
next month, first week, madam.
List on 6th of August.
It's
Yes.
a short point, my Lord. The
Sale number,
plaintiff had executed a registered release deed. Lord, the declaration.
I'll
suit is-
hear first
Very
week
well,
of August.
very well.
sale number,
6th of August. Yes.
Great.
sale number
20.
20. H.E. Gundeloda.
Petitioner,
Thanks,
please.
sir.
It is stated that in the cause list, the cause title itself, it is stated that the notice to other respondents may be dispensed with as relief is only against respondent number 1. Accordingly, notice to the other respondents is dispensed with at the risk of appellate. Yes.
This is a petition filed by the third defendant before the trial court, Your Honor. An application was filed by the 30th defendant seeking rejection of plaint. The suit was for the relief of or permanent injunction in respect of agricultural land. The plaintiff has claimed that the suit property is the unauthorizedly occupied by the plaintiff and as well as along with his wife, each measuring 2 acres. And as on the date of filing the suit, there was no revenue occurs in their name, Your Honor. And moreover, at para 17 of the plaint.
Please come to your affidavit. We'll read your affidavit and understand.
Yes, please. Yes, please. Internal page 38, please, Your Honor.
Yes.
I submit that at page para 16 of the plaint, it is averred by the plaintiff that I have purchased the land bearing survey number 231 of Kapoor village from defendant number 1 to 12. And on a complaint given by before the jurisdiction police, it was advised by them to endorsement dated at so to resolve the dispute before the civil court. I would request Your Honor page internal page 32 of the please, Your Honor. It is a page para 16 of the plaint, please, Your Honor.
You're the owner of the property, accepts it.
No, they have narrated in the plaint that the suit property is.
Comes with impugned order. Impugned order.
No, Allah, page plaint pleading, please, Your Honor.
I have read that.
Yes, please, Your Honor.
Please come to the impugned order.
At page 19 of the impugned order, sorry, internal page 19, please, Your Honor.
All judgments.
Page 8 of the impugned order, please. Before filing the suit by the plaintiff,
He had given a representation to the Lokayukta place, rather telling that there is an unlawful interference by the 13th defendant, under of the 13th defendant, in respect of suit property. In the next page, Your Honor, para 9 of the impugned order, the plaintiff further submitted the after withdrawal of the suit by Gopalaya. Gopalaya is the person to whom it was land measuring 4 acre was granted in the same survey number. And the property which was granted to Gopalaya came to be reported and new number is assigned as admitted by the plaintiff in the plaintiff.
No, your case is something else. And the court gives a finding that you have sought rejection of the plaint on the ground of limitation.
No, not for limitation, Your Honor.
But that is what is the order.
No, section 31 and the 21.
That's what, but the order is that. The court, entire order court discusses about the limitation.
Yes, please, Your Honor.
Please come.
Para 9 of the impugned order, please, Your Honor.
The land counsel appearing for the petitioner, defendant submits that when an application is filed on order 7 rule 11 stating that the plaintiff has admitted the fact that the plaintiff has purchased the property by endorsement dated 25/11/2023. They have also filed a suit voice number 119 of 2003 seeking permanent injunction, and the same was withdrawn. Plaintiff has given a complaint to Lokayukta. And in the light of the fact that they're accepting that the petitioner has to purchase the property, a bare suit for injunction is not maintainable. And the court, without considering the same, giving some other unconnected reasons, has dismissed the IA. Considering the submission, they shall be stay of all further proceedings pursuant to the order dated so and so. Petition is permitted to take out hand summons on the counsel appearing for the respondent. We shall file a memo to that effect by 28th of July, or else the stay granted by this court stands vacated.
Till number 21. Abhishek,
21, the petition has become infructuous. They themselves have filed a memo. It may be disposed of.
What is the memo?
My lords, they had filed this petition against an order of the trial court refusing to extend the ex parte interim order, my lords. The applications came to be disposed of on merits, my lord. They came to be dismissed on merits. As such, the petition becomes infructuous.
So what happened?
An ex parte interim order was passed, merits of injunction, that was not extended on the sole ground that they have filed the written statement. I knocked the doors of this honorable court. This honorable court was pleased to protect me and direct disposal of the IS on merits. Now the IS are decided on merits.
Yes. Where is that order?
Merits 10/7/2024.
It is submitted by the council that by order dated 10/7/2024. The court has protected the interest of the petitioner, and the temporary injunction order is continued. And at the same time, the court has directed the trial court to hear the interlocutory applications pending before it and to pass a reasoned order. Thereafter, the court has considered IA number 1 and 2.
IA number 2 and 3.
2 and 3 and pass the order. In that view of the matter, nothing survives for consideration in this writ petition. Accordingly, writ petition is dismissed as infructuous.
Great.
till number 22. Abhinav Ramadan for petitioner.
Appearing for the respondent number 1.
For the petitioner.
You appear for respondent?
Respondent number 1.
What about 2 and 3 furnishing of PF?
Ma'am, my lords, this is coming for the second time. Will take steps.
How many times it should come?
I just make one submission.
Will take fresh address. It may kindly be taken up next
Court
week.
has already passed a judgment on 23rd of June, similar matters.
Take
Let me
that.
just hand that over. Connected matters, an application under 7 Rule 10 came to be rejected by the trial court. series of
Order passed for
23
the commercial court, so and so is set aside and consequently application is allowed. The suit stands transferred to the jurisdictional court, Bangalore Rural District.
I just request a similar order be passed.
You are the plaintiff?
I'm plaintiff before the trial court.
Yes, same order will pass.
Could it be taken up in the next week, my lord? Senior will come and address. Our
Want to
contention
allow
is
your
that.
application, you say that,
Please, my lord. I mean, it was with respect to the jurisdiction of the commercial court, so confusion, I apologize.
the present petition is filed. Where is the order impugned?
Hundred and ten, page number 110.
110? The The petition is agreed with the order passed in commercial OS number, in IN number 5, in commercial OS number 14 of 2024, dated 16th June 2025, whereby the court has dismissed an application that is filed by defendant number 3 under order 7, rule 10, read with section 151 CPC. When the matter came up for hearing, Land Counsel appearing to the respondent plaintiff submits that this court in WP number 21874 of 2025 and batch dated 23rd June 2026 has passed an order by setting aside the order passed by the commercial court and transferred the suits to the jurisdictional court, Bangalore Rural District. Bangalore in the light of the considering the submission of the Land Counsel for the respondent plaintiff and in the light of the orders passed in WP number 21874 of 2025, date 23rd June 2026, this court is passing the following order. The order dated so and so passed by so and so is set aside. And consequently, the application that is IN number 5, look at it, is allowed. And the suit stands transferred to the jurisdictional court, Bangalore. The jurisdictional court, considering the fact that these matters have been pending since 2019, shall expeditiously decide the matter. The matter shall continue from the same stage. The jurisdictional court, everything is the point. The jurisdictional court shall not grant unnecessary adjournments. Then what about notice to the other defendants? How will they know?
This court has actually has also observed that trial court may issue notice to the
And the
unserved
trial court
respondents.
shall issue notice to the parties. Yes.
Number 23.
One correction, respondent number 1 plaintiff. I don't appear for the other respondents.
Yes, only on one.
Other
I said
one.
plaintiff.
Yes. Okay, which other? Then number 23, Suresh Hasi.
The memo is fine, seeking to convert this writ petition into a regular. How can you convert? The procedure is entirely. How can you convert into regular first appeal this? The petition may be converted into a regular first appeal. So the matter is arising out of an order, an application or 21, order 21 rule 54, 95, 99, 100 under section 47 read is 151 CPC is dismissed. Considering the same, the memo is taken on record and the petition is permitted to convert this writ petition into a regular appeal within a period of 2 weeks from the date of receipt of the copy of the order. These kind of orders, whenever a time fixed, priority. Yes.
Cell number 24, Pawan BK.
First statistic.
There for petitioner. We have the remedy to file an appeal is available. It may be disposed.
Appeal before this court or
before the moment this court.
you want to withdraw or you want to convert?
I want to withdraw.
A memo, the Land Counsel for the petitioner submits that. as per the objection raised by the office, the writ petition is not maintainable and they will file a regular appeal. The liberty may be granted. Accordingly, the council submission is taken on record and the writ petition is dismissed with the liberty to avail the appropriate remedy within a period of 2 weeks from the date of receipt of the copy of the order. The registry is directed to return all the documents by keeping the Xerox copies. Yes.
Number 25, Virupakshaya PH.
Hearing for petitioner, my lordship, as per your direction, we have implemented the respondent number 7 as my lordship, Power Grid Corporation, my lordship.
What is this matter about?
My lordship, in this, my lordship, Power Grid Corporation started.
So you have to issue notice to R6?
Yes, my lordship.
Notice to R6?
R6 and proposed depending. R6 as well as the
Proposed
respondent.
Respondent.
That IE?
My lordship.
R7.
1 minute.
R7.
Where is that IE?
We have filed, my lordship.
IA number 1 of 26 is filed to implead, seeking, to whom you want to implead?
My lordship, Power Grid Corporation, my lordship.
He wants to implead the Power Grid Corporation. Will you appear for that?
But I'm not appearing.
Power
I'm
Grid,
appearing.
who appear?
Let someone appear.
Samuel.
If somebody is there, panel counsel,
This
why
is
should
panel
you
council
unnecessarily
is
waste
there.
time?
Panel council.
So and so is directed to take notice on behalf of the proposed party and shall come up with their objections. Notice to 6th respondent. This matter on 4th of August, or not 4th, on 11th of August. Yes.
Cell number 26 disposed, 27, Fayaz BG.
For petitioner in this case, my lord. But as per the directions of this court, my lord, the hand summons have been served to all the 3 respondents. The acclaimment for having served the hand summons is also placed on record before this court.
That is, you appear for R1, 2 and 3 you have taken out.
Pardon, Lord?
But 2 and 3 you have taken out hands.
All the 3. After service of the hand summons, this R1 has
This
appeared.
file stating that the petitioner has taken out hand summons to the council appearing to the respondent before the trial court. Hence notice to R2, already Wakalat is filed on behalf of R1. Notice to R2 and 3 is held sufficient. Yes. You want to argue the matter?
Next week, any date, Lord.
Yes, let's this matter. Next week not possible. Let's just on the-
Lords, I appear for the petitioner in this matter. Lords, R1 and R3 have been served. My lords, I'll take out fresh notice to R2 and R4, my lords.
Have you taken out hand summons?
No, my lords, I haven't taken out hand summons.
Take out.
In fact,
No,
I'll
petition shall take
take
out
them
hand
so far as R2 and R4. my lords.
R2 and R4 are concerned, and shall file a memo to that effect within a period of 2 weeks. Yes.
Cell number
Interim order
29,
may be extended, my lords.
There is no interim order in that.
There is an interim order, my lords, of status quo that was.
28?
Please, my lord. It was passed on 14/5/20.
Interim order earlier granted is extended. List this matter on 19th of August. Case 29.
cell number 29,
I filed power. I have
29.
filed power for sole respondent.
You will?
I have filed power for the sole respondent.
Yes.
May I please?
When is the impugned order passed?
Annexure A is the impugned order.
27th March 2026.
Please.
What is this IA?
The IA is filed under order 21, rule 22A. And your lordship will get the application at page.
No, we can go to the order straight away.
No,
Please
my submission to your lordship is last time also I made a submission. The application filed under order 21, rule 22A may not be the correct. But I made a submission that a liberty may be given for me to make a fresh application. That is the reason why your lordship directed, another one more submission I am making. Your lordship, they filed execution petition. Then we filed objection. That without considering that objection, see, ultimately impugned order came to be passed. My submission to your lordship, let the trial executing court decide on my objection, because section 47 of CPC.
No, you won't stay till such time.
Pardon?
You want the stay of execution till such.
Because ultimately section 47 says whatever the dispute raised before the executing
What do you
court,
say?
it has to be decided.
We'll ask the court to decide this application within a week. Till such time, no, don't precipitate the execution procedure. The petition is agreed by the order dated 27th March 2026, passed in execution number 124 of 2018 by the full senior civil judge and CJM Tumkur. He has filed an application under order 21, read with rule 22, order 21 rule 22A, read with section 151 CPC to stay or set aside the order of execution of sale deed through court commissioner on the ground of substantial prejudice caused to the legal heads due to the death of original judgment debtor that came to be dismissed by the court by order impugned.
27.
The court has observed that the order 21 rule 22A of the CPC deal with sale not to be set aside on the day and the death of judgment debtor before the sale, but after service of the proclamation of sale. But in this case, after compromise decree, the original judgment debtor has not executed the sale deed as per the compromise decree. Now, after filing this execution petition, when the notice was issued to the judgment debtor, they came to know that the Dalapa died. Now still the sale deed was not executed with the court commissioner. Hence the question of stay or set aside the sale deed executed with the court commissioner does not arise, and accordingly dismiss the petition. And when the matter came up for admission, as it is submitted that they will file an appropriate application, and the application that is filed is not as per the procedure, then this court has ordered notice to the respondent, then counsel for the respondent has filed wakalat. Next para, and counsel, it is submitted that the matter may be remanded to the petition may be, the liberty may be given.
Your lordships, I say.
Yes, appeared, and he submitted that the court has rightly passed an order, order dismissing the application, considering the fact that the petitioner wants to file an appropriate application. This court deems it appropriate to pass the following order. The order dated so and so, passed by so and so, is set aside, and it is left open to the petitioner to come up with an appropriate application within 1 week from the date of receipt of the copy of the order.
Your lordship may also say that application, you let him withdraw and file fresh application. The order will.
No, that's why I've said I have set aside, and the petitioner shall come up with an appropriate application within a period of 1 week from the date of receipt of the copy of the order.
For me to file objection.
And within 1 week, you want 1 week time from there on.
No, I'll file immediately.
Within 1 week from there on, the court shall decide the application.
After giving me an opportunity to file my objection.
Next, number 3, till such time, till the exercise is completed by the court as per the timeline fixed by this court, the respondent shall not precipitate
the executing court may not take further steps.
Execution court shall not take further steps.
No, one sir. We filed objection to the main petition that without considering
Let
that.
him go and ask that contention there. It will consider.
That your lordship.
Then you don't want this application. I'll ask the court to consider that.
Please, if that objection
is set aside, and the court is the executive court is requested to consider the
objections filed by him.
Filed on 10/12/2020.
Consider the objections filed by the petitioner
on 10/12
to the execution petition. How much time it takes generally for a court to exercise?
Because section 47 says
we will go
that it is like
it shall be decided expeditiously.
Please.
Till such time, the executing court shall not proceed with the execution. Yes.
Till number 30, Siddharth Suman.
Grateful.
Yes.
Your lordships, if I can be granted
Non-compliance of office objections, counsel submission.
My lords, I just seek an adjournment. My lord, senior had a personal exigency. He had to travel. It can be taken up on
The office
Tuesday. My lords.
objections shall be complied with. once office objections are complied,
My
this is
lords,
the
might
matter.
be taken up on Tuesday, my lord, there's certain
See, you
urgency.
comply with the office objections, it will come. Yes, 31.
Appearing for the petitioners, my lord. We are challenging the impugned order at page number 70, my lord, wherein the trial court.
What about your office objections?
My lord, office objection is subject to the payment of the court fees. I have paid it, my lord, digitally.
Petitioners are not a party to the impugned
Yes, my lord.
annexure 1. Clarify as to why they are
I
not
have
party.
stated in my petition, my lord.
Huh?
I have stated in my petition, these petitioners are the tenants of the respondent number 2, who is a party in the trial court, my lord. I'll take your lordship to that. Court
No,
fees I have paid.
Please forget about the court fees. Now, you have filed this.
Challenging the impugned order at annexure.
Thank you. Please show the plaint before the trial court.
My lord, I'll take your lordship to the execution petition at annexure K, page 65.
Page?
65, 65, my lord.
Yes.
My lord, therein your lordship would find the judgment debtor.
Who is the judgment debtor here? Where is the judgment debtor here?
Judgment debtor is the respondent number 2 in the present petition. That is Sri Shayyad Habibullah. Page 65, 65, my lord. Annexure K, my lord.
I'm looking at the cost title of
Please,
this petition. In this, where is Mr. M. Srinivaslu?
He is R1, my lord.
He is?
R1, my lord. Respondent number 1. Your lordship would find at page number 10.
He is Srinivaslu.
Then respondent number 2 on the next page, page number 11. That is Sayyid Habibullah. Sayyid Habibullah has executed a rental
And
agreement.
who are all these parties?
This
Who are all
petition-
these petitioners?
That's what, my lord. These petitioners are the tenants inducted by respondent number 2 herein, my lord. I have produced the.
These parties to the IA that is
No,
filed.
my lord.
If they are not, just like that, you can't make them parties.
No.
You should ask the leave of the court.
My lord, that's why I have stated in the petition, my lord, by saying that these petitioners are inducted as a tenant by the respondent number 2, my lord. We have stated in.
Just like that, you will make somebody as parties in a writ petition under 227.
No, I have produced the rental
I'm
agreement.
sorry, Mr. Counsel, if you're not understanding, I can't help you.
My lord,
You have to make the parties who are the parties before the trial court.
I have made.
Other than that, if any other parties are there, why you have to file an application for that. Just like that, you can't make them a parties.
My lord, that's what we are.
The office objection shall be complied with.
My lord, one submission. If your lordship pass or I'll file the appropriate application because delivery
No
warrant is
passwords.
executed.
Does this matter once office objections are complied
My
with?
lord,
Yes.
32, Basavaraju P.
First defendant civil revision petition. If I had application for rejection of client.
Where is the counsel for the respondent?
Copies have been served them, my lord, they have entered a caveat.
We'll see, it's a old matter, no urgency, no. This is matter
Well, the
on 13th of August. Yes, 33.
Number 33, Prasanna Kumar BT.
Some inconvenience is there, my lord, to
Yes,
see.
list is in the month of September. Yes.
Number 34,
Lord, any short date may be given, my lord.
Sridhar.
Yes.
Peter K.
I pray for short accommodation.
Yes, this also in the month of September.
Number 35,
Hearing for plaintiff, my lord.
C. Shankar.
Notice to the respondents.
My lord, 2 to 11 dispense, my lord, as they are co-defendants in trial court, my lord.
2 to
11.
memo is filed second dispensation of notice to respondents 2 and 2 to 11 dispense with at the risk of appellant. Yes.
Number 36, Nagesh Muru.
This is identical to what was there yesterday, my lord. In this case, my lord, what has happened is two small facts, my lord.
Respondents
The
has become
we
infractious.
filed, my lord,
Petition has become infractious, madam.
what if the proceeding is set aside, my lord, it becomes infractious. The reason is this, my lord. What has happened is, my lord, they moved an application before the RERA authority to refer it to civil court.
Can I just see the prayer?
Yes, ma'am. If your lordships will take, my lord, 36269.
No, prayer before this court.
Yes, prayer, my lord, is at page 20.
Faxing the order dated 10/11/2025, passed by the so-and-so execution
Yes.
petition.
That order, your lordships
This
will get, my
application
lord.
stay of further proceedings has been. So now this court has granted the stay.
Yes, now, my lord,
To precipitate the matter.
now in this case, there is a stay, my lord. I'll just explain, my lord, a little background, my lord. They got a compromise was filed before the RERA authority and an order was made. They made an application to RERA authority to permit them to file execution and transfer this to the executing court, city court. That order was made. Then, my lord, matter goes to city court and the court has issued notice. So at that stage we are here. We made an application before the RERA court authority to say that please recall this order because there's no power given to the executing court to pass this. The RERA authority has passed orders in all 4 matters before your lordships today, 2 different dates, saying they're recalling that order. In the interregnum, my lord, what had happened was we had moved an application in the executing court to say stay the proceedings. And the Honorable Executing Court, my lord, had said I can't stay the proceedings because of Supreme Court order. Now your lordship saw, my lord, the other order passed by the learned single judge saying that civil court has no jurisdiction. The Honorable Court had directed us to file an application in that case, yesterday's case, for to bring to notice.
So in this case, when the RERA order itself is recalled, nothing remains to be adjudicated.
That's true, madam.
May I make one submission, my lord? My learned friend, the joint memo has been executed by both the parties. My lord, is before the Lok Adalat and an award came to be passed. Your lordship is aware if an award is passed under section 20 of the LSA, my lord, is deemed decree. My lord, RERA authority don't have jurisdiction. It's only the executing court that can proceed, my lord.
They're relying on a judgment of the Justice Nagaprasana's judgment is said that RERA's order is not an executable decree.
My lord, this is under the Legal Service Authority Act, Lok Adalat. It's not before the RERA. The RERA authority has not passed the order.
It's an order under the RERA only. Please see the order, my lord. Your lordships may peruse the order.
By the matter was compromised before the Lok Adalat.
Before the Lok Adalat, my lord, as terms were agreed, it goes to the RERA. RERA passes the order.
Sorry, my lord. Subject to correction, my learned counsel, I'll pass the award. We filed a memo as part of the record also.
If your lordship has one of the cases, my lord, 36269.
So I'm looking at 36291.
Yes, in that, my lord, your lordships will get the order, my lord.
Then what is the mode available for execution?
They have to go to the RERA authority only because that is what, my lords, under section 40, the RERA authority has the power.
My lord, it's the award passed under section 21 of the Legal Service Authority Act. It's not under by the RERA authority.
Karnataka State Legal Services Authority before the Lok Adalat.
Please, my lord. That's the award that is passed.
This is examined, my lord, by the RERA authority.
Joint memo on record filed by both the parties. The joint memo is taken into account. That has not been challenged at all. That has not been challenged. The award is not challenged till date. So, my lord, your lordship is aware, under 21, it's a deemed decree. I have to go to the.
And where is this order of the RERA? How come the RERA authority has passed that order? Let's see that order of the RERA.
My lord, this argument is considered by RERA and negatived, my lord. Could your lordship see, I filed the order passed by RERA on an application to recall. All this is examined.
There is a.
That is, my lord, I filed a memo on 3/12/25 in 36291. 36291. A copy of the order is produced. The order date is 17/11/25. The order begins, my lord, at page 4.
Some documents of 26/11/2025.
It is a memo dated 3/12/25 in 36291.
There is nothing 3/12. One appears to be on 21/4.
May I pass on another copy, my lord, for immediate reference? I have a certified copy, my lord. My lord, the text of the order, my lord, begins at page 4, I think. Paragraph 2, the court notices the facts. During the pendency, parties entered into a joint memo of settlement dated 11/2/23. before the RERA Conciliation Center, Lok Adalat. The same was duly recorded in the respective complaints and the complaints to disposed dated 11/2/23 on those terms. Under the said joint memo, developer undertook to complete infrastructure works, power drainage, etc. upon formation of the owners association. Timelines were agreed. Since settlement was recorded Lok Adalat proceedings on 11/2/23, these complaints to disposed and attained the status of a decree of a civil court under section 21 of the Legal Services Authority Act. Upon expiry of the timelines, complainants filed a decree transfer petition under section 40 and 57 of the RERA Act, read with Rule 26, seeking transfer of the decree to civil court. The DTPs were allowed without issuing notice to the developer. The developer, after filed the
Have you
present.
questioned this order of recall?
Yes, my lord. That they have filed it, my lord, they have questioned that the order came to be passed. It's in the appellate court, my lord.
It is before the?
Appellate court, RERA appellate authority. It's an appeal.
Oh, that's where you have to,
For the
appeal is pending.
appeal is pending. I have the submission, my lord, it's an award passed in the Lok Adalat.
No, that's true. No, in the light of the orders passed by the RERA.
There's a distinction, my lord, by a judge, my lord. It says very clearly, only RERA orders, my lord.
Correct.
It's not
But
a
the
order.
RERA has withdrawn that order.
No, my lord, RERA had not resolved. They only took it on record. There was that.
Use the mic. Yes.
They've only taken it on record, my lord, that's all. They have not adjudicated nothing. It's by the local, in the Lok Adalat, the joint memo came to be filed, and based on the joint memo, my lord.
Our findings on point, in view of the above discussion, this application deserves to be allowed, hence we proceed to following. Where is the order? Only the proceed to following is there.
Pardon, my lord?
Para 22 says, we
Yes.
proceed to pass the following, there is nothing after that. Take that.
Oh,
My lord,
so
the
sorry.
joint, Lord, may kindly have a look at the joint.
The
memo.
operative portion,
That's
the-
been filed.
1 minute. Let's clear up one order.
Operative
In
portion.
exercise of the powers conferred under so the order passed in the decree transfer petitions in CMP number are hereby allowed. You accept the facts that basing on this transfer of decree by the RERA to the executing court, now the execution proceedings are pending. Unless and until this order is set, this order, whatever the appeal you have sought, unless and until you succeed in that, you cannot proceed with the matter before the executing court.
My lord, my humble submission, my lord, they do not have jurisdiction once it is an award.
You are
Award
going
passed
beyond-
and the
no,
act
no,
is not
that is on the
passed.
merit- that
My lord,
is-
the order is not passed by RERA.
Understand,
Please,
that is
madam.
on the merit. You have gone to the civil court not basing on an order passed by the Lok Adalat.
No, we
You
only
have
sought for transfer. We sought for transfer because that they don't have the power. It is that court. If you also may kindly read section 40, it says very clearly, if they cannot, execute this order, it has to be transferred to the civil court for adjudication, for execution. That is what section 40 says.
That
My
I
lord,
see.
being a decree, they cannot do it. So that is why they transferred the matter to the executing court.
That they have withdrawn that.
No, my lord, that's what I'm saying, my lord. They didn't have the power at all.
Where will you agitate this?
No, my lord, it's not been challenged. The award has not been challenged till date.
I think you have to answer to my question.
Please, my lord.
There is an order transferring the award or the execution to the executing court.
Yes, please.
Basing on that, the execution proceedings are going on before the executing court.
Please, madam.
Now, an order is passed recalling the transfer of execution to the executing court.
Please.
That order you have questioned in the before the appellate authority. Till the appellate authority passes any order, there is nothing before the executing court to execute.
My lord, my humble submission was, my lord, the very memo that what they filed was not maintainable. Because, my lord, it's an award.
Yes, it is not maintainable, but there is an order on that.
Please, my
In
lord.
due course, whoever is competent to deal with it will deal with
My lord,
that.
if they admit that it's an award under section 21, my lord, the RERA authority, there's a clear distinction, my lord, in the judgment that was passed earlier.
You have
Only,
to, you can't argue like that.
no, my lord,
You can't argue on the merits of the matter. No, there is a procedure for everything.
please, my lord.
Now, that order is now before the appellate authority. Appellate authority has to say it is right or wrong. After that, you have your subsequent whatever remedies you have. As on now, what it stands is, there is nothing for the executing court to decide unless and until your appeal is decided by the appellate authority.
My lord, my submission was, it's become infructuous in view of the order passed there. See, my lord, the order what they challenged was, my lord, at the first instance passed by the appellate, by the RERA authority. My lord, when that being the case, my lord, when an award is passed, how will the RERA authority have any power, my lord?
I'll pass orders. Reserved.
Excuse me. Lord, in para 2 of the operative portion, the RERA authority says, my lord, that their liberty is reserved to them to move the RERA authority. That's the remedy.
Bill number
Great.
37, N. Harish, for
Interim
petitioner.
orders may kindly be continued.
It will be continued when
Great.
amount is- Yes.
Bill number 37, P. N. Harish, Rajendra MS, HS for petitioner.
Yes. Why the memo is moved for a 25 matter?
I have not moved.
Why the court officer has moved?
I have not moved the memo, my lord.
No, I'm saying both of them have not moved, the court officer has moved. On 25/6/2026, MS Rajendra.
25/5.
That's how it is, it has come up in the list.
Long back you
You only moved.
Long back.
No, 25/6, not so long back.
Please, my lords,
maybe.
Yes. Why, what is urgency with this?
Now, my lords, what has happened is a delivery warrant is issued and it's the property of this respondent. She had succeeded.
Very warrant is issued way back in 2025.
What has happened is, my lords, it's a 1996 suit. 2000 it got decreed. Since 25 years, she is not able to.
Let's just matter on 16th as a first case.
Lord, 16th already, my first case is already, will be second case because the lordship on the other day.
Doesn't matter, it will come the next one.
Please,
When I say
please.
first case, it will come as second
Please,
case.
please.
Bill number 38,
Yeah, for the
Rajeshwara PN.
petitioner, my lords. Urgency is, my lords, because of the pendency of the suit, we are not able to
Everybody has urgency
understand, my
in
lords.
all the matters.
It's a matter, my lords, where my written statement is refused to be taken by the commercial court. A short point, my lords.
And that is,
Whether 120 days have, on what date the 120th day expires is the question for my lord's consideration. That's the only point, my lords. Plus, suit summons was served through RPID on 1/5/24 and 2/5/24, my lords. Along with the suit summons, a copy of the plaint was not served. Through the of the honorable court, the suit summons with the copy of the plaint.
see the act, what it says.
It has to be accompanied by the plaint, my lords.
No, what it says, let's see the act,
Commercial.
commercial courts. Yes.
Let's schedule, my lords, may take order 5 and order 8.
Order?
Order 5 and order 8, my lords.
Yes.
My lords, but order 5, rule 2 of CPC, my lords, clearly says copy of every summon shall be accompanied by copy of the plaint, which is also part of the commercial courts proceedings. This was not accompanied. So on the summons was served through the on 23rd May 2024, my lords. 23rd May 2024. Written statement is filed on 20th September 2024.
How many days?
Exactly 120 days, my lords. The court says it is 121 days, but if the 23rd date is excluded, my lords, 8 days in May, 30 days in June, 31 days in July, then
What do you say?
That so far as written statement is concerned, it shows that 21/9. They have produced that.
No, he
copy
says
of-
20th.
They have sent it.
sent it on mail on 20th,
May.
my lords, because the hearing date was not there on 20th. 21st was the next day.
That 21st is the date of that is signing of the written statement or what's the fine.
But it is beyond another day.
No. It was sent to the honorable
Annexed
court by email on 20th, my lords. Kindly see the impugned order.
I'll see some other day. Let's just matter on 23rd of July as a first case.
Great friends. interim
Yes.
order.
Number 39.
Yes.
Here for the petitioner in this matter. For petitioner, my lords.
Which-
So as per direction by your lordship, I have served upon them.
Yes, what do you say? What are your instructions?
Let that, now earlier we have issued a notice calling upon him to produce the document for disbursement of compensation. Where this honorable court file objections to consider that the objections have been filed and personal hearing provided the order has been passed. Even despite that they have resisted, we will move before the district magistrate for removal of obstruction under section 16(1) of the Telegraph Act.
Now, what is this? What is the order now?
The order that
I mean,
earlier,
what is the question?
That's Annexure G.
Annexure G, which
Let's
has
see the
been came
prayer.
into passed by virtue of the directions of this
Correction
honorable.
quashing the order dated 11/3/2026.
Please, my lords.
What is this order dated 11/3/2026?
That this order came into pass by virtue of the directions of this honorable court. Earlier notice was issued on 9/12/2025.
No, how can you pass an order and like?
That earlier this honorable
What I
court.
asked you
Yes,
the
yes.
other day when the matter came up.
Earlier this honorable court not where that they have issued a notice to file objection, let consider. That we have considered and pass on it. Even despite now that resisted not, we move before the district.
What is your authority to
That's
consider?
my not that.
Why should
However,
you
not that
consider?
this honorable court gives a direction.
Lords,
That
there
not that we'll move before the district magistrate.
Matter comes up, you should tell the court that that you cannot consider. It is for the deputy commissioner to do
The
it.
deputy commissioner,
When
that we'll
I
move
asked him-
before the
When
district.
I asked him the other day, he was specifically saying that.
We'll move before the
Lords,
district
they have-
magistrate.
Now, this order has to go.
Yes, yes, ma'am. This order has to go with the liberty to the
Yes.
Lords,
respondent to
my-
move before the
my-
district magistrate.
Shall I make my submission in one more fold? For in the interest of natural justice, if I kindly take your lordship to section 10 of the Telegraphic Act.
No, the
No,
other
no,
day,
which
you were
pro-
saying that this telegraphic act itself is not applicable.
Assuming that for the sake of argument, my lords, it is applicable, section 10D provides, my lords, the authority has to make sure that the least title damage would cause to the person who is in the possession of the land. My lords, petitioner before this court is an aged lady. She is a senior citizen. What all I am submitting is that, my lords, whatever the compensation amount they are giving, I don't require that amount. Let them consider my alternate alignment. I am not telling that they should
They will not do it. You go
Let
before
each-
the,
My lords,
you go-
that-
you
that
go
obs-
before the deputy commissioner. Deputy commissioner will do that.
My lords, that observation may be made. My lords, I am not resisting them from
I will not make
establishing
any
the
of
line.
those observations. They are before the deputy commissioner. The deputy commissioner will issue notice to you and he will pass orders.
Yes.
There, whatever you want to agitate, you agitate
My
there.
lords, till then, no precipitative action shall be
Why
taken.
will they take?
No, they are
Present
trying to
petition-
erect, my lord, that's why.
Present petition is filed seeking the following prayer. It's a case of the writ petitioner that the petitioner is the absolute owner and possessor of agricultural land bearing survey number 27/3 measuring 1 acre 30 guntas situated at Basavana Shivanakare village, Parmasagara, Hobli, Chitradurga Taluk. The respondent number 3 has issued a notice dated 9/12/2025 proposing to draw a 220 kV transmission line through the petitioner's land. And she was called upon to furnish the stamp paper for obtaining the compensation. Questioning that the petitioner has filed WP number 38245/2025, which came to be disposed of on 9/12/2025. Where is this order?
That's at
Annexed.
page 25, operative portion is at page 30.
Disposed of by order dated 19 December
Page
2025.
29.
Whereby this court has disposed of the representation holding that the notice dated 9/12/2025 shall be treated as a show cause notice and the petition shall file the objections and the respondent shall consider the same and pass orders. Now, by considering the said, in the light of the said order, they have passed an order dated 11/3/2026. Petitioner is before this court questioning the said order. The petitioner has raised several grounds before this court. Mr. Devraju appearing on behalf of the respondents 2 and 3.
2 and 3.
2 and 3 submits that the competent authority to take a
But
decision.
that even if they resisted, not that competent authority, district magistrate to removal of obstruction.
If there is any obstruction, the competent authority is the district
Magistrate,
deputy commissioner.
not district magistrate.
Is the?
Yes, yes, ma'am. Act says that word is district magistrate.
District magistrate. The competent authority is a district magistrate. and they will approach the district magistrate.
Under
and
section
obtain the-
16(1) of the.
Under 16?
Of the Telegraph Act.
61.
16(1).
16(1) of the Indian Telegraphic Act, and they'll obtain necessary orders. Until
Follow-up
such
steps.
time, they will not take any coercive steps. Land counsel for the respondent submits that the petitioner does not want compensation. They want the realignment of the line. Even in that case also, the more remedy available to the petitioner is before the deputy commissioner. In that view of the matter, this court is passing the following order.
That's on
The order
submission.
impugned dated so and so is set aside. Either if as it is already, the respondents have, either the petitioner or the respondents, whoever are aggrieved, they have to take any further steps. They have to approach the district magistrate as per section 16(1) of the Indian Telegraphic Act, number 3. The district magistrate, after considering the case of both the parties, will pass appropriate order. Next.
In accordance.
In accordance with law, till such time, the respondents herein shall not shall not precipitate the matter
In the land of the petitioner.
in the land pertaining to the petition.
That's one submission.
Telva.
My submission to the extent that the alternate alignment has to be. Now that
Why should I say so? That's
cannot
not
be.
the domain of the court. That is
No, my lords.
I said I recorded your
Deputy
submission.
Commission shall consider that proposition.
I
in
will not
accordance
say
with-
that. Yes, next.
Till number 40, Srinivas V.
For respondent number 1 and 2.
Yes.
Lord, the urgency in this matter is
2
that,
and
my
3.
lord,
sir. For respondent number 2 and 3.
Yes.
Lord, the urgency is that the third respondent, that is the AEE, my lord, they have issued a notice threatening to disconnect the electricity.
What are your instructions?
Already, this writ petition will become infructuous. Swami. On 2/7/2026, pursuant to Annexure E notice, electricity was disconnected. If they furnish the required document, the court can with the liberty dispose of the petitions. On 2/7/2026.
It's already disconnected, it seems.
Disconnected.
My lord, I'll seek further instructions on that, my lord.
Yes, if you want any amendment, you can file. Land counsel, the petition is filed, questioning the anticipating disconnection by the respondents, and the land counsel for the
Respondent number 2 and 3.
land counsel for appearing for respondent number 2 and 3, Mr. So and so.
Vinayaka VS.
So and so submits that. Already the power is disconnected on 2/7/2026. Land counsel for the petitioner wants to, she wants to get specific instructions in this regard. Does this matter on
Date, my lord.
23rd of July?
Submission. Item number 36. I may be permitted to file compilation of the orders passed by RERA, recalling the earlier order.
Give it to the court officer.
My lord, can I request for a passover in this matter, my lord, serial number
Because I'm
40?
not sitting in the afternoon.
My lord, at least the matter may be taken up on Monday or Tuesday. my
Monday,
lord.
what will you do? Unless and until you seek for amendment and file a petition before the court, that can't be heard. In fact, this should be dismissed, giving you, that will be more better so that it will come in the fresh matters. What I'll say is, in the light of the fact that already the power supply is disconnected, this writ petition is dismissed with the liberty to file to file it if there is any cause of action, to file a fresh writ petition, so that the matter will come immediately once you file. Shall I do it?
My lord, either way, they
Just
have
sit
to
on
seek
Monday.
instructions. Much obliged, my lord.
But tell your senior that Monday I will not consider anything unless and until your any further pleadings are there on record.
2:30, my lords, Monday 2:30.
No, 2:30. It will come on Monday whenever it reaches. How many matters are coming up on Monday?
In the afternoon. Already. ಹೋಗಿದ್ದಾರೆ. They're asking us to furnish, disconnect already ಆಗಿರೋದ್ರಿಂದ they want to us to furnish something like that. What side is back here? Instructions are here. My lord, my senior is waiting, my lords. He's online. They're not permitting inside, my lord. Kindly, permission may be granted for him to come inside, my lords.
Why he's not permitted? Somebody is appearing online and he's not permitted.
Serial
Why?
number 40, my lord.
Huh? Just look at it. Yes.
Registrar ಆಗಿದ್ದಾರೆ. He was there few minutes back. Due to some technical glitches, he was sent outside. Srinivas V.
ಶ್ರೀನಿಧಿನಾ?
Srinivas V.
ಶ್ರೀನಿವಾಸ್ ಇಲ್ಲ, ನಾಟ್ ಇನ್ ದಿ ಆನ್ಲೈನ್.
ಅವಾಗ್ಲೇ ಇದ್ರು 10 ನಿಮಿಷ ಕೆಳಗೆ.
Sir, go to memo option, sir, please. There's a memo there.
Memo is memo.
Yeah. Mentioning interest.
Monday.
Hello.
ಇಲ್ಲ ಇಲ್ಲ, ಆಮೇಲೆ ಎಷ್ಟೊತ್ತಿ ಆನ್ 13/7 ಮಂಡೇಗೆ. ಆಮೇಲೆ ಮತ್ತೆ ಹೇಳಿದ್ರು ಈ ಕಂಟಿನ್ಯೂ ಎಂಟ್ರಿ ಮಾಡು, ಡೋಂಟ್ ಫರ್ಗೆಟ್ ಇಟ್, ಲಿಸ್ಟ್ ಇಟ್ ಆನ್ ಮಂಡೇ ಆಸ್ ಫಸ್ಟ್ ಕೇಸ್ ಇನ್ ಲಿಸ್ಟ್ 1.